गुड आफ्टरनून सर। हमारे बीच आज के रिसोर्स पर्सन आगे हैं। गुड आफ्टरनून एवरीवन। एम आई ऑडिबल? सर नमस्कार सर। I Dr. Renu Chaudhary on behalf of HRDC and on behalf of the all participant I welcome you sir. Dr. शिफाली मैम अभी हमें रिसेंटली ज्वाइन कर लेंगे, तो बस हमें 2-3 मिनट दीजिए आप, फिर हम आपसे मिलते हैं जी। थैंक यू सो मच।
गुड आफ्टरनून सर।
गुड आफ्टरनून सर।
काफी दिनों बाद मिल रहा हूँ सर।
हाँ जी बिल्कुल ठीक कह रहे हो आप।
सर यूनिवर्सिटी में तो मिल लेते थे आपसे।
कुछ कमजोर लग रहे हो आप अब।
नहीं सर नहीं। और ठीक है सर आप?
हाँ जी बिल्कुल बढ़िया है।
तो
आप लोग कब से स्टार्ट हुआ है जी ये प्रोग्राम?
ये 1 Feb से स्टार्ट।
तो हम तो मिड फेब में मिल रहे हैं अब, तो अभी आई थिंक मिड हो गया है ये प्रोग्राम का।
जी सर।
ओके चलो गुड। आई होप यू आर ऑल एंजॉयिंग इट।
फिजिकल
फॉर्म में भी कोई है आप? चलो मैम आ गए हैं, लेट अस स्टार्ट।
Four persons
okay good.
From the Department of Law and from the legal professions.
Right.
Yes.
जी वेरी गुड आफ्टरनून सर। नमस्कार, आपका बहुत बहुत स्वागत है हमारे आपके अपने डिपार्टमेंट के अंदर, आपकी अपनी यूनिवर्सिटी में वर्चुअल प्लेटफॉर्म पे, और सभी प्रतिभागियों की ओर से अपनी ओर से आपका बहुत स्वागत करती हूँ और धन्यवाद देती हूँ फॉर ज्वाइनिंग विद अस। एंड बहुत ही जो मैं कहूँगी कि आज का टॉपिक बहुत आप सब लोगों के लिए बहुत रेलेवेंट होने वाला है, क्योंकि ये आरटीआई के ऊपर है। इसके ऊपर बहुत सारे लोगों के डाउट्स हैं।
ഒക്കെ ചെയ്യാ പിന്നെ കോൺഫിഡൻസ് ഇപ്പോ ഒരു അഥവാ ഒരു പോയിന്റ് സ്കോർ ചെയ്ത് അവർക്ക് കേറിയെങ്കിൽ നമ്മൾ ഡൗൺ ആവരുത്।
एजिबेट जी म्यूट योरसेल्फ। एजिबेट जी म्यूट योरसेल्फ।
सो और बहुत सारे जो हम लोगों को जानकारियों की आवश्यकता है वो आज सर हमारे साथ शेयर करेंगे। दिस सेशन विल बी ऑन द आरटीआई एंड सम रिफ्लेक्शंस फ्रॉम आवर ओन एक्सपीरियंसेस ही विल बी शेयरिंग। सर वी हैव मेनी पार्टिसिपेंट्स फ्रॉम लॉ फील्ड इस ग्रुप के अंदर। आपके अपने
यस मैम
जानकार भी हो, आपके स्टूडेंट्स भी हैं। देखिए शी इज देयर,
माय जूनियर्स, माय कोलीग्स एंड माय फ्रेंड्स आल्सो।
जी जी जी। सो may I ask Madam Renu to introduce sir with all the participants?
Yes, yeah ma'am, sure. Just give me 1 second. Good afternoon again, sir. So let me introduce, and it's immense pleasure for us that you are here. So Dr. Pawan Kumar, Department of Laws, BPS Women University, and academic qualification BCom, BGMC, MMC, LLB, LLM, and PhD Law. And administrative experience, First Appellate Authority, BPS Women University, Khanpur, Nodal Officer, Legal Grievances and RTI, BPS Women University, Khanpur, Kalan, Nodal Officers also at the same university, Khanpur, Kala, Sonipat. And his research projects are completed a University Grant Commission, New Delhi, sponsored research project titled Honor Killing in Haryana, a socio-legal critic in 2014, organization of training program. He has organized one-day training program sponsored by National Human Rights Commission, New Delhi, on human rights for women under Indian constitutional law. सर के अंदर बहुत सारी रिसर्च गाइडेंस भी दी है इन्होंने। कुछ स्टूडेंट्स हैं जिन्होंने पीएचडी कंप्लीट कर ली है, कुछ अभी अंडरगोइंग है। बहुत सारे पब्लिकेशंस हैं जर्नल्स एंड बुक में, और यहाँ पे बहुत बड़ा सीवी है सर। मैं सब सारा तो नहीं एक्सप्लेन कर पाऊंगी। बहुत सारे रिसर्च पेपर्स हैं, बहुत सारे कॉन्फ्रेंसेस हैं, नेशनल सेमिनार्स हैं, इंटरनेशनल कॉन्फ्रेंसेस हैं, वर्कशॉप्स हैं, पेपर प्रेजेंटेशंस आल्सो, नेशनल कॉन्फ्रेंस एंड ऑल। एंड sir, on the behalf of HRDC, एंड ऑन द बिहाफ ऑफ ऑल द पार्टिसिपेंट मैं आपका अभिनंदन करती हूँ, आपका स्वागत करती हूँ जो आपने अपने बिजी शेड्यूल से हमारे लिए समय निकाला। और हम वेट करेंगे कि आपसे हम बहुत सारी चीज़ें सीखें जिस तरह से आप हमें बताएंगे। आज बहुत सारे लोगों को आरटीआई के बारे में नहीं पता है, कुछ लोग यहाँ लीगल फील्ड से हैं, कुछ नहीं है, तो आज हमें है कि आपसे हमें बहुत सारी जानकारियां मिलेंगी जिससे हम सभी को फायदा होगा। वेलकम अगेन सर, थैंक यू सो मच।
थैंक यू। If Professor Saif Ali is listening to me, may I start, ma'am?
Yes, you can start, sir. You can start. All are here, sir.
Thank you. Mera, first of all, I welcome all of you to this Women University, although we would have liked to welcome you in a physical form rather than virtual form. Because being physically interacting with each other is a different experience than meeting virtually. Although the information which we are supposed to share or which we will share with each other, it is hardly makes any difference if we are physically or virtually we are there, right? So whatever has been said about me, I express my sincere gratitude to Human Resource Development Center, what earlier and nowadays what we call it Academic Staff College, right? Because they have provided this opportunity to me to interact with you. And the point of interaction or the topic of interactions on which we are thinking to deliberate, because I want that once before starting my deliberation, let me know the participants' background. There are 22 participants. So what I wish that everyone please introduce and be on screen. Because if I keep on speaking on screen without you being there, it doesn't look nice. I will not be able to understand your expressions. Your participations would not also be very active. So I do not want it to be a one-way traffic. I want it should be both-way traffic. Everyone should participate. Let it be a participative discussions, deliberations, rather than delivering a lecture. Right? So I request everyone to kindly introduce within 1 or 2 lines your profession, your subject, and your place of work especially. Thank you.
नमस्कार सर, मैं अमित कुमार, गवर्नमेंट कॉलेज दुबलधन, असिस्टेंट प्रोफेसर हिस्ट्री।
Okay, thank you.
नमस्कार सर, हेलो।
हाँ जी,
नमस्कार सर, I am Keshav Burman. I working at Gorbata College, West Bengal.
Sir, we would be happy if you are available on video also. That would be fine.
What, sir?
If your video is not on, we are not able to visualize. So
yes, sir.
if we visualize, suppose tomorrow we meet, we may pass through each other. We may not know each other. Yes, thank you.
Okay, sir. Thank you, sir.
So you are also welcome. Virtually you are connected?
What, sir?
Virtually you are attending this program?
Yes, sir. All are virtually.
All are
attending virtually, sir.
Thank you. Thank you.
All are attending virtually.
And Mr. Keshav, what is your subject?
Sir, my subject is political science.
Political science. Okay, thank you.
Yes, sir.
Please proceed further.
Subhash ji.
जी। Good afternoon, one and all. Good afternoon, Pawan sir. This side Subhash from Agrawal College, Ballabgarh, Department of English and Foreign Languages.
Okay, welcome.
Yes, sir. Thank you, sir.
सर नमस्कार।
नमस्कार मैडम
जी।
डॉक्टर गीता, असिस्टेंट प्रोफेसर हिस्ट्री, शहीद उद्यम सिंह गवर्नमेंट कॉलेज मटक माजरी, इंद्री, करनाल।
ओके जी मैडम, वेलकम, आपका भी स्वागत है जी। नेक्स्ट।
थैंक यू सर।
Good afternoon, sir. Myself, Mrs. Arti from Adampur, FGM College, Adampur. I am assistant professor in English.
Okay, मैडम वेलकम, आपका भी स्वागत है जी। नेक्स्ट प्लीज।
Good afternoon, sir.
Good afternoon from sir.
गुड आफ्टरनून जी।
ठीक है अजीत मैम आपको आप बोल दीजिए उसके बाद में
प्लीज
My name is Agibet Matthews. I am working as a physical education teacher in Vidyalaya College, Thrissur, Kerala.
राइट वेलकम मैम
Okay,
यस
thank you.
प्लीज प्रलय कुमार
हाँ गुड आफ्टरनून सर
गुड
आई एम प्रलय कुमार भट्टाचार्य फ्रॉम गढ़बेता कॉलेज वेस्ट बंगाल
वेलकम
हाँ एक्चुअली आई एम लाइब्रेरियन ऑफ दिस कॉलेज
ओके वेरी नाइस
थैंक यू सर
Good afternoon, sir. I'm Dr. Farhana, Assistant Professor at Gurugram University, Gurugram, and मैं आपकी student भी रही हूँ in Khanpur in LLM.
Welcome. We are very happy that you are there in our profession, right? Welcome.
गुड आफ्टरनून सर
Good afternoon.
सर मैं विजयपाल सिंह मैं एमआईटी यूनिवर्सिटी गुड़गांव में हूँ सर लॉ पढ़ा रहा हूँ यहाँ पे पिछले 4 साल से
Welcome, Dr. Vijay.
थैंक यू सर
Good afternoon, sir.
Good afternoon.
I'm Dr. Balram Gowda, Bairamji Jijiba College, Mumbai University, and my teaching is I teach accounts, and my background is commerce.
Okay. Welcome.
Thank you, sir.
Thank you. There is one request. It's a request that please keep your video on. It should remain live class because I will be interacting with everyone.
Yes, sir. Yes, sir.
Yes. Anyone else?
Yes, sir. I am Kumar Hasda, Assistant Professor in Botany from Garbeta College, West Bengal.
Very good. Welcome, sir.
Yes, sir.
नमस्कार सर
Namaskar.
डॉक्टर जोगिंदर सिंह असिस्टेंट प्रोफेसर इन ज्योग्राफी गवर्नमेंट कॉलेज रसिया
Okay. You welcome, Joginder ji.
थैंक यू सर
Yeah, rest of the participants. Okay. So should I start?
Yes, sir.
जी सर
देखिए आज हम लोग because what I see it's a very heterogeneous group in the if I go by the subjects, but if I go by the profession, it is homogeneous group that we are all teachers, right? So that way, I hope that whatever we are going to discuss, it's a very interesting subject. What I was asked to give a topic, and the topic was right to information, right, in India, some reflections. So when we talk about, because all of we know that we are fortunate to be born in a democratic country where governments are elected by our choice, right? And when we say that governments are elected by our choice means by when we express our opinion through the secret ballot voting, right? And when there is a expression by us, there is an opinion of expression, collective opinion. And when government is formed, that opinion has to be formed on some information, some basis. There must be some logic for our expression, right? Some background must be there. Some, I would say, the root would be there, some base would be there, and how we form all our opinion. कैसे हम लोग अपना ओपिनियन जो है वो बनाते हैं. एक डेमोक्रेटिक कंट्री के लिए बहुत जरूरी है कि भाई लोग जो ओपिनियन बनाएं, वो ओपिनियन अगर बनाएंगे तो क्योंकि गवर्नमेंट जो हम क्रिएट करने जा रहे हैं, द गवर्नमेंट विच वी हैव इलेक्टेड और द गवर्नमेंट विच इज गोइंग टू गवर्न अस, विच इज गोइंग टू रूल ओवर अस, which is going to decide our subject matters from very basic, like from our like birth, taking birth in a democratic country. So someone regulates that birth. It is not that there is, because when you say that, and the kind of democracy which we have adopted, parliamentary form of democracy, where we have decided that our representatives, they will be taking decisions on the affairs from our birth, womb to tomb. They will be taking decisions when you are in womb, how our mothers need to be treated, what kind of nutritions need to be given to them, right? And so that we are born in a healthy, right, environment as well as physically, both. So how it is possible, and what kind of representative we should choose? For choosing the best representatives, it is must that we should know the information about our representatives. And all what we know about right to information, when our forefathers, our framers of our constitution, when they decided to frame a constitution for India so that this vast country may be regulated, may have a rule based on that book, what we call constitutional law, or the principles on the basis of which this society decides to strive, decides to move forward. So, what kind of constitution we created? We all know that there are basic organs of the state which have been created by our constitution. And the same constitution has granted certain fundamental rights to citizens as well as some fundamental rights to non-citizens, right? The persons who are there in India, either they are citizen or non-citizen, even foreigners, they do have certain rights. Now, what are those fundamental rights? As you are all aware, some of you, almost everyone knows that Part 3 of the Indian Constitution, it has guaranteed certain fundamental rights to the citizen as well as non-citizen. Now, among those rights, if I see it, and you must have read them, from Article 12 to Article 35, that you see, all those articles, none of them talks about right to information explicitly. So it was in case of Indira Nehru Gandhi versus Raj Narayan that all of us know that this particular case had, I would say, implications for our democracy in a way that elections of a sitting Prime Minister of India was declared illegal. She was debarred from contesting elections for 6 years for certain practices in violation of the law of the land. And to know what kind of practices has been adopted, what kind of activities were taken, because it was alleged by the petitioner, Sri Raj Narayan, before Allahabad High Court, that look, there has been illicit activities, the public servants, officials, they have been engaged in elections of Mrs. Gandhi to the disadvantage of other candidate, and it is a misconduct during that party, during that time, or we can say that there was unfair means adopted in the elections. These were the allegations by the sitting Prime Minister, that the election, the government machinery has been misused for election of a particular candidate. These were the challenges. And he sought certain informations that I may be provided the informations so that I prove all these activities, although he had some proofs. So he had demanded about Blue Book and other activities during her election. And at that time, the highest court of this country, Honorable Supreme Court, observed that citizens have a right to know in a parliamentary democracy, because unless people know, they can't decide They can't form opinion. It is not first case. Later on, all of you are aware that in 2003, Association for Democratic Rights, there was again, it was pleaded before the Delhi High Court that the citizens have right to know antecedents of a candidate contesting elections for the parliament or legislative assembly, especially how many number of criminal cases a candidate is facing, because at that time there were deliberations. Even Law Commission has expressed concerns on criminalization of Indian politics. And rather, even today, when I was reading that India's government has expressed strong resentment on the statement of the Singapore Prime Minister, which was given day before yesterday in the house of their parliament, and especially on the statement that almost half of the persons those who are facing criminal cases, they are sitting in Indian Parliament, and which is of course a matter of concern. But fact doesn't change. Our government may have shown concern, but it's a hard reality that yes, almost 33 to 40% of the persons, our representatives who have been elected by the people, they are facing criminal cases before courts, right? Although it was stated at one point of time, if I am not wrong, at one point of time in 2014, the present political party which is in regime, at that time, its prime ministerial candidate, and today who is our prime minister, Honorable Sri Narendra Modi ji, he has in 2014 announced publicly that if his government is voted in power, he will bring a legislation to ensure that the parliamentarians who are facing charges before the courts, their decisions or their cases are decided within 1 year. This was one of the public statements. Although no substantial step has been taken on that side, I do not find any amendment in the law till date to that impact that yes, someone who has been elected with the charges will be given a speedy trial or some special courts will be established for them, right? I have not seen. So what I was telling, that in 2002, when Delhi High Court was deciding this case, that criminal antecedents of a candidate who is contesting general elections, either for parliament or legislative assembly, that candidate is supposed to declare through an affidavit number of court cases pending, criminal cases pending against him or her, apart from educational qualifications of the candidate, as well as any dues to the government. Although there were two other conditions. But what I wish to say is that the Election Commission was directed by the Honorable High Court that Election Commissioner will seek affidavit. Every candidate is under an obligation. As citizens have a right under Article 19, Clause 1A, that is fundamental freedom of speech and expression, to know antecedents of a candidate who is contesting elections from their constituency. They have this fundamental right was declared, right? Although it was not expressly there, but impliedly it was there, that people, when they speak or when they express themselves, either through voting or someone else through some other means, that they should know, especially the activities which are undertaken by the public officials while discharging their official duties. No one is supposed to know what an official is doing at home, what an official is doing at other places than the workplace. That is none of our concern. Now, as we are aware that this particular fundamental right to know, when Article 19 Clause 1A is also not absolute, because there are reasonable restrictions which may be imposed by a law on certain grounds which have been specified under Article 19 Clause 2 of our Constitution. Now, in order to realize this right, as well as when some non-government organizations, when they went to Rajasthan and they had to seek information from the panchayats on the utilization of funds received from the government, either central government or state government, that how those funds have been utilized, how much has been received, where they have been spent. These NGOs, they faced many challenges. They were not able to get information. Public officials were denying information to them, and they had no means. Therefore, there was a campaign, there was a movement for legislating a law on right to information. Freedom of Information Act, which was there in 2002, which was enacted. But ultimately, when we talk about right to information in India today, so we have two kinds of right today. One right is the fundamental right, for enforcement of which we are all know, those who are from law background, the law teachers, we all know that, look, if we talk about fundamental right to information of the citizens, that right is to the citizen, that right is implicated under Article 19 Clause 1A, as has been pronounced by the Supreme Court as well as the High Courts. That right is not absolute. Reasonable restrictions can be imposed by law, by the Parliament of India. That is also known to us. And for enforcement of that fundamental right, citizen has been given two remedies. If a citizen is deprived of that right to information, what are the remedies? I'm talking about fundamental right now. The first remedy is that citizen can file a writ petition in nature of writ of mandamus before the concerned High Court, means the High Court of that state, under Article 226. As Article 226 empowers the Honorable High Court of every state to issue writ in the nature of mandamus if fundamental rights have been violated. As I told you, this is one of the fundamental rights if it is violated. But for that, an individual, a citizen, need to approach the Honorable High Court. And petitioning someone in Honorable High Court some public officials is an expensive affair in India. Although it is very efficacious remedy, it is a remedy wherein the judges of the high courts who are independent, they may assess and they may decide, but it is very expensive remedy. Another remedy which is available is under Article 32, which empowers that the citizens, in case of violation of their fundamental rights, they are entitled to approach the Supreme Court of India straightway without availing the remedy under Article 226. It is written there, although it is hardly exercised these days because the Honorable Supreme Court most of the time insists that you should first approach your respected high courts under Article 226 for issuance of the writ of mandamus, because Supreme Court of India is also empowered under Article 32 to issue writ of mandamus against the state for infringement of any fundamental rights, including the right to information. And when we talk about writ of mandamus, what is this? Actually, it's a writ which tells that in case there is a violation of fundamental rights by the state or its instrumentalities, which I will talk about that also. Instrumentalities means if the state is not doing something, because for under Article 12, state has been defined for the scope of fundamental rights, that what is state, and it is stated there that unless the context otherwise requires, state includes the government, Parliament of India, Government of India, Legislative Assembly of each state, Government of each state, as well as local authorities or any other authority. As far as Parliament of India, we all understand it because it has been established under the Constitution of India. Its composition has been given there. So we can understand, we can know. Same way the Government of India, Union of India, what we call, is also defined in the Constitution. So we can all know that. We know from there that what is Union of India. And in the similar fashion, we know the legislature of each state because that is also defined in the Constitution. Executive of the state, that is also defined there. Local authorities, when we talk about local authorities, Journal Clauses Act 1887, it defines local authorities that all self-governing institutions like panchayats, municipal corporations, they are local authorities situated within the territory of India or under the control of the Government of India. As well as other authorities, there has been questions that what is other authority under Indian Constitution. So the number of cases have been there. The Supreme Court, in case of a regional engineering college, it has given a theory, although theory was given prior to this particular judgment, a constitution bench, 5 judges bench, it pronounced the instrumentality or agency test, that the state is not doing something itself. If it is doing something through an instrumentality or agency, which has been created by a act of parliament or act of legislature, suppose like electricity board has been created under an act, or some public corporations has been incorporated like ONGC or some other agency. So for discharging a duty, which is basically given to the state. So state cannot escape its responsibility. State cannot crumble over, ride over, infringe the fundamental rights of the citizens through that agency or instrumentality. That is not allowed. And they will also be known as a state, including the universities. This is what universities provided. There is a rider. And rider is if most of the expenses of that university or association or agency or instrumentality or organizations which has been created by a law or under a law by the state or parliament. So such agency would be a state for Article 12. This is what court laid down. If almost all the expenses of that agency or instrumentality or organizations have been incurred or has been provided by the government of India or the government of a state. Also, if there is a pervasive control, it means if it is largely controlled by the government of India or the government of a particular state or parliament or legislature or local authorities, such agencies or instrumentalities will be state, right? Now, apart from this, we are all aware that the remedies under Article 32 is also not inexpensive. Rather, it is an expensive affair. It is not possible for every citizen of India, especially in view of the expense, in view of the knowledge which is required, because a person whose fundamental rights has been infringed can only approach the Supreme Court. This was a ruling up to 1980s. Although from 1980s, there came another concept, the concept of the public interest litigation, or what Professor Upendra Bakshi pronounced social action litigation, that a third party whose rights has not been infringed, even that third party can approach the Supreme Court for the enforcement of the fundamental rights of the poor, needy, or someone who can't afford to avail that remedy due to what I would say poverty or ignorance, right? Which gave rise to this concept of public interest litigation. Now, this movement by the non-government organizations for making an efficacious mechanism, laying down a practical information regime in India in such a way that a common person, an ordinary citizen of India, can seek information from the public functionaries when there was such a demand. So it was in 2005 that the Parliament of India passed the Right to Information Act 2005. Almost, I hope everyone is aware about it. RTI Act. Is there anyone who is not aware about this particular legislation? अभी मैं आप लोगों के पास आने वाला हूं, right? I think all of you know it.
Yes, sir.
Yes. Those who do not belong to legal discipline I request them to please come forward and tell what they know about RTI. Yes, I will be going to, I should go to whom first? Let us go to Parloy Kumar first. Yes, Mr. Parloy Kumar, can you hear me?
Sir, RTI means if we have any question or query about anything.
आरती बोरिया जो है ना, सी स्पीकिंग. चलिए आपका जो सब्जेक्ट है वो कौन सा है मैडम? विच सब्जेक्ट यू आर टीचिंग?
English.
Yes. So what you know about RTI?
Right to information. If
ये तो है, देखिए, this is one thing that this is right to information. भारत का संसद ने, the Parliament of India, उन्होंने 2005 में एक कानून पास किया. One law was enacted, namely the Right to Information Act 2005. ये एक बात आपको मालूम है.
हाँ जी सर.
इसके अलावा ये एक्ट जो है किस तरह का कानून ये बनाया है, what kind of machinery has been established, what are the duties of those that machineries which has been established, उसके बारे में भी कुछ आप बता सकते हैं क्या?
Sir, if have any query about any institution, or then we can ask from the head, or he will supply this information within 15 days, sir. I think so, sir.
ठीक है. देखिए, इन्होंने कहा कि भाई सपोज यू नीड सम इंफॉर्मेशन फ्रॉम हेड ऑफ ए डिपार्टमेंट, so we can ask. Being a law English teacher, professor, she thinks so. Although we know that this particular act, subject to the provisions of this act, it entitles all citizens to have a right to information. It means it guarantees a statutory right. What is statutory right? Because earlier we talked about fundamental rights. There is this question also sometimes, that what is the difference between a statutory right and fundamental rights, right? उस बारे में भी हम बात करेंगे. तो Madam Aarti Boria, can you please tell me, have you heard these two words, fundamental rights and statutory rights?
Statutory rights तो मैं I think नहीं सुना है सर, लेकिन fundamental rights तो सुना है सर starting से. हाँ जी.
हाँ जी, आप इस बारे में ना, there are like what people have expressed the views, the experts, that fundamental rights means the basic rights.
Yes sir, आधारभूत जो हमें मिली हैं, जैसे एजुकेशन का. हाँ जी.
Rights हैं.
हाँ जी.
However, our constitutional experts, they say that fundamental rights means those rights which have been guaranteed in Part 3 of the Indian Constitution.
Yes, sir.
That's because the name of that chapter, Part 3, starts with the fundamental rights. So that is why they say that the rights which have been guaranteed by Part 3 of the Indian Constitution. And what I told, that the fundamental rights in Part 3, so that right, if it is violated, that fundamental right, first of all, is against the state. State and when it is violated, one can go to the High Court or one may go to the Supreme Court. If we talk about right to information as a fundamental right, first and foremost it is for citizen only, because Article 19 Clause 1A, under which it is stated by the court that it belongs to this particular article. It resides there. So for that, in case of violation of the Article 19 Clause 1A, one can approach the High Court or Supreme Court. High Court under Article 226 and Supreme Court 32. Right?
Yes, sir.
But in case of statutory right, it means such a right which has been given by legislation, by an act of the Parliament or a legislature, right? Like Right to Information Act 2005, it was passed by the Parliament of India, right? In 2005, right? As Act number 22 of 2005. Now in 2005, when Parliament was in session, was doing its business, Act number 22 was presented, it was passed and notified after receiving the assent of the President of India on 15th June 2005, this particular act, why it has been passed, there is a preamble to this act. And I will talk about that later on. When there is a statutory right, so there is a legislation, a specific legislation like this, which has been passed, which may be passed by the parliament, like in this case, it is by the Parliament of India. Or it may be passed by the legislature of a state, right?
Yes.
Some states, they have been authorized to make rules under this act. Like Haryana has made it a rule that the SPIOs, State Public Information Officers, they can seek identity of a person who is seeking information from an institution. Now, from an institution or from whom we can seek RTI, I will talk about that also. But when I talk about statutory right, it means a right which has been given by a legislation, right? Enacted by the parliament or by a state legislature. This is one thing, right? Now, what Madam Aarti told us, that look, you can seek information. And what the act makes a provision under section 3. Act declares that every citizen has a right to information subject to the provisions of this act. Now, what is this? How we can understand it? It means all citizen of India, every citizen of India has this right, statutory right, under the Right to Information Act, to seek information, right to information, subject to, but that is not, it means it is not absolute right, it is a condition that this right is subject to the provisions of this act. It means RTI Act. It means it is not an absolute right. There are certain conditions, there are certain provisions, there are provisions of this act to which this right is subject to. It means this right somewhere has to be read in the context of this particular legislation. That this right may not allow you right to information in every situation. There are situations in which you can seek the information, and there are organizations from which you can seek the information. Now, what are those organizations? What are those situations? वो भी हमें जानना है. We are here to know it. If I can, because another thing is, right to information है, किसके अगेंस्ट है? अभी इस बारे में मोनू बंटी यहाँ कोई जुड़े हुए हैं. यस मोनू जी, आप जो है ये बता सकते हैं आपका सब्जेक्ट एरिया कौन सा है?
हिस्ट्री है सर.
हिस्ट्री. तो आप आरटीआई के बारे में क्या जानते हैं? जो आरटीआई एक्ट, हाँ जी,
आरटीआई जो है ना सर, जैसे हम किसी भी जो है गवर्नमेंट जो इंस्टीट्यूशन है उसमें लगा सकते हैं, या फिर मान लो कोई जैसे नगर पालिका है, कोई पंचायत का काम है, कुछ हो रहा है, उसके अगेंस्ट फाइल कर सकते हैं कि भाई हमें, तो मान लो जैसे शमशान घाट की बाउंड्री कर रहे हैं, मान लो छोटी सी बात सर, कि भाई कितना पैसा आया है,
ठीक है,
कौन टेंडर लिए हुए है, क्या क्या इसमें आपने भाई कैसा माल लगाना है, कैसी ईटें आएंगी, उसका हम ब्यौरा मांग सकते हैं.
ठीक है, आपका ये मानना है.
जो गवर्नमेंट के कुछ जो एनजीओ हैं, कुछ गवर्नमेंट
बिल्कुल उनका भी हम देखिए, इसी पे हम लोग चर्चा करते हैं.
किसी पर्टिकुलर आदमी का हम डेटा नहीं मांग सकते.
ओके, चलो इसी बात पे हम चर्चा करते हैं. जैसे मनोज जी ने बताया कि भाई देखिए, व्हाट वी आर नाउ गोइंग टू डिस्कस ओवर इट. ये एक तो हमने देखिए पहले सेक्शन 3 में कहा था कि राइट टू इंफॉर्मेशन है, वो सब्जेक्ट टू दिस पार्टिकुलर एक्ट है. अब ये राइट टू इंफॉर्मेशन में जब हम डेफिनेशन क्लॉज में जाते हैं, सेक्शन 2 में डेफिनेशन दी गई है. बहुत सारी डेफिनेशन इसलिए दी जाती हैं, जब भी कोई एक्ट होता है पार्लियामेंट का, तो उसमें एक डेफिनेशन क्लॉज होता है. और डेफिनेशन क्लॉज भी, देयर आर 3 टाइप्स ऑफ डेफिनेशन क्लॉजेस. एक तो हम ये बात जाने कि भाई व्हाट इज डेफिनेशन क्लॉज एंड व्हाट काइंड ऑफ डेफिनेशन क्लॉजेस आर देयर. क्योंकि जब आप के सामने कोई कानून का व्यक्ति है, वो बात कर रहा है, तो हम कानून की बात करेंगे कि भैया ये डेफिनेशन क्लॉज का एक ही पर्पज होता है। उस एक्ट में जब हम कोई बात लिखते हैं या कोई एक्सप्रेशन लिखते हैं, व्हेन वी डिस्क्राइब सम एक्सप्रेशन इन द एक्ट और सम वर्ड्स, व्हाट इज द मीनिंग ऑफ दैट एक्सप्रेशन, उसका मतलब क्या है उस एक्सप्रेशन का। जैसे मान लीजिए राइट टू इंफॉर्मेशन है, तो राइट टू इंफॉर्मेशन का मतलब क्या है वो समझने के लिए हमें डेफिनेशन क्लॉज में जाना पड़ेगा, क्योंकि हमें ये तो पता लग गया ऑल सिटीजन हैव राइट टू इंफॉर्मेशन सब्जेक्ट टू दी प्रोविजंस ऑफ दिस एक्ट, कि भैया इस एक्ट को के अंदर जो राइट दे रखा है वहां तक आपको देयर इज ए राइट टू इंफॉर्मेशन। आई होप एवरीवन इज गेटिंग मी। मुझे लग रहा है कि जो बात मैं कह रहा हूँ वो कम से कम समझ में तो आ रहा होगा।
सर समझ में आ रही है
सर डेफिनेशन इंक्लूसिव हो सकता है,
हाँ,
एग्जॉस्टिव हो सकता है।
वेरी नाइस।
देयर आर मेनी टाइप्स ऑफ डेफिनेशंस, लाइक इन टैक्सेशन आई हैव हर्ड इट इज इंक्लूसिव, then it is inclusive and exhaustive, so there are many types of definitions, three types of definitions are there।
थ्री टाइप्स का जो मैं बात कर रहा था, ये इन्होंने बहुत अच्छी बात बताई। हमारे वन ऑफ द पार्टिसिपेंट्स में हमारे साथी भी हैं, टीचर डॉक्टर बलराम जी ने, कि देखिए देयर आर थ्री टाइप्स ऑफ डेफिनेशंस। जब लॉ में कहते हैं कि सम डेफिनेशंस दे आर एग्जॉस्टिव, यू कांट गो बियॉन्ड देम, राइट। जो भी कुछ डिफाइन करना है वो वर्ड के बारे में और एक्सप्रेशन के बारे में, whatever one has to describe, the act has to say about an expression, that has been told there in that definition. There is exhaustive definition. You can't go beyond that. Second is what is told, that inclusive. It means you can include similar expressions which have been prescribed there, defined there, or explained there. You can put other expressions of similar nature there, right? Third is the combination, right? It may be combination of both. Some part may be exclusive, some part may be inclusive of an expression. ये भी हो सकता है, right? Very nice. Thank you. अब देखिए हम लोग बात कर रहे थे कि राइट टू इंफॉर्मेशन, क्योंकि मुझे जो मोनू बंटी जी ने बताया कि किससे मांग सकते हैं, तो इन्होंने कहा कि भाई शमशान घाट का बाउंड्री है, कोई सरकारी संस्था है। तो राइट टू इंफॉर्मेशन जो है डेफिनेशन क्लॉज में जब हम जाते हैं, व्हेन वी गो टू द डेफिनेशन क्लॉज, लुक एट द डेफिनेशन क्लॉज, सेक्शन 2, most of the act you will find section 2, either section 3 maximum, right? Definition clause you will find there. So what is there? We find that right to information means right to information accessible under this act, which is held by or under the control. A बहुत important word. By or under the control of any public authority. It means you can seek information from a public authority, and such information must be held by or under. It is not necessary. Suppose I am the vice chancellor of a university. It is not necessary that each and every record is in my office, although it is under my control. It may be placed in some other office of the university, right? Or it may be held by the vice chancellor. So when we say by public authority or under the control of public authority, now, and includes the right. Now inclusive definition है, includes the right to inspection of work, और भी बहुत इसमें दिया हुआ है. I am not going into detail. 4 kinds. There are 4 kinds of categories जिसमें right दिया है. इधर inspection का है, taking notes और extract का है, certified material का है, like diskettes, floppies, videos, उसमें भी receive करने का you have right. Now, what is public authority? क्योंकि जब आप बात उठते हैं कि public authority क्या है, because ये जो basic right है, तो right is the information which is held by or under a public authority. So important thing is to know what is public authority. And again, we need to seek the help of the definition clause to know what is public authority. So there we find that section 2H, it tells about public authority. And it says public authority means, meaning has been told, it means any authority or body. Authority means someone, some organizations which has power, jurisdiction, or some organization. Body means organization, agency, or institution of self-government established or constituted by or under the Constitution. It means if something has been established by the Constitution, like Union Public Service Commission, an institution established by the Constitution of India, like Election Commission of India, institution established by the Constitution of India. You will find Supreme Court of India. You will say high courts, every high court. These are the institutions apart from Union government, state government, Parliament of India, Legislative Assembly. You will find that there is the office of the President. You will find there are other provisions also, public services, right? Now, all these institutions which have been established by or under the Constitution of India, they come within the ambit, within the meaning of the public authority. Second categories of the institution is by any other law made by Parliament. It means all the authorities which have been created by the Act of Parliament. Suppose you will see that in India, independent India, there has been 7,000 to 8,000 legislations by the Parliament of India till date. You will find that yes, there is the Indian Railway Act, there is a Railway Appellate Tribunal, Income Tax Act, you will find there is a Water Act, you will find there is a Air Act, you will find there is an Environment Protection Act, you will find there is a, sometime we would say, Unlawful Assemblies Prevention Act, you will say this RTI Act, you can say Right to Services Act, right? There are number of acts. We have what we passed, Manrega Act, Food Act, we find the Hindu Marriage Act. You will find there are number of acts, right? Now, all those acts have established some institutions. Now, all the institutions which have been established by the legislature, by the Parliament, right? Indian Army Act, Indian Navy Act, all these have been established by the Parliament. Or any other law made by the state legislature. Like these days, if I talk about our own state of Haryana, like yesterday, the Supreme Court of India was dealing with an interim order of Honorable High Court of Punjab and Haryana on an act passed by the legislature of Haryana for reserving 75% of the positions for the residents of Haryana, for the domiciles of Haryana. Now, the legislature enactments by the legislatures of the legislative assemblies, all those institutions, those are also included. Third, by notification issued or made by the appropriate government and includes any body owned, controlled or substantially financed directly or indirectly by the fund provided by the appropriate government. When we say by notification, the government, appropriate government, and when we say appropriate government means वो भी यहाँ डिफाइन किया हुआ है इस एक्ट में. अप्रोप्रिएट गवर्नमेंट का मतलब है अगर कोई ऐसा, व्हेन वी टॉक अबाउट अप्रोप्रिएट गवर्नमेंट मींस किसी पब्लिक अथॉरिटी के जब हम बात करते हैं, अगर वो अथॉरिटी एस्टैब्लिश्ड, कंट्रोल्ड, कॉन्स्टिट्यूटेड और सब्सटेंशियली फाइनेंस्ड बाय द सेंट्रल गवर्नमेंट, तो वहां उसका मतलब है सेंट्रल गवर्नमेंट. और अगर यूनियन टेरिटरी है तो भी वहां उसका मतलब है सेंट्रल गवर्नमेंट. और कोई बॉडी which is substantially financed, controlled, owned by the state government, तो वहां मतलब है स्टेट गवर्नमेंट. अगर हम बात करें भगत फूल सिंह महिला विश्वविद्यालय का, जहां से हम बोल रहे हैं, तो इट इज सब्सटेंशियली फाइनेंस्ड बाय द गवर्नमेंट ऑफ हरियाणा. तो यहां अप्रोप्रिएट गवर्नमेंट का मतलब होगा गवर्नमेंट ऑफ हरियाणा. और अगर मैं बात करूं इनकम टैक्स डिपार्टमेंट की, कोई ऑफिस इनकम टैक्स डिपार्टमेंट का जो सब्सटेंशियली फाइनेंस्ड है बाय गवर्नमेंट ऑफ इंडिया, तो इसका मतलब वहां मतलब है उस ऑफिस का गवर्नमेंट ऑफ इंडिया। और इसमें कहा गया है कि देखिए, और ये भी बहुत इंपॉर्टेंट है, नॉन गवर्नमेंट ऑर्गेनाइजेशन सब्सटेंशियली फाइनेंस्ड डायरेक्टली और इनडायरेक्टली बाय द गवर्नमेंट ऑफ इंडिया और अप्रोप्रिएट गवर्नमेंट ऑफ स्टेट। अब एनजीओ जो है वो एनजीओ इसमें आते हैं only those non-government organizations which have been substantially financed by the government of India or government of a state। इस बारे में भी मैं थोड़ा सा बातचीत करूंगा कि भाई जो, क्योंकि एक ऐसा केस आया जहां एक कोऑपरेटिव सोसाइटी, प्राइवेट कोऑपरेटिव सोसाइटी, उसका कुछ इंफॉर्मेशन जो है उससे मांगा गया आरटीआई एक्ट में। तो ये बात उठी कि वेदर द प्राइवेट cooperative societies, whether the information held by them or under their control can be accessed under Right to Information Act। तालापल्लम सोसाइटी का बात उठा, तो तालापल्लम सोसाइटी में ये सुप्रीम कोर्ट ने कहा कि ये जितना एक प्राइवेट जो बॉडी है, एक कॉर्पोरेशन है, कोऑपरेटिव सोसाइटी है, द इंफॉर्मेशन टू दैट एक्सटेंट विच मे बी आस्क्ड बाय द रजिस्ट्रार ऑफ ए कोऑपरेटिव सोसाइटी, बिकॉज कोऑपरेटिव सोसाइटी एक्ट हैज बीन पास्ड बाय द लेजिस्लेचर ऑफ स्टेट, और वहां रजिस्ट्रार का ऑफिस एस्टेब्लिश कर दिया गया। तो रजिस्ट्रार के ऑफिस से वन में सीक द इंफॉर्मेशन। अगर वो इंफॉर्मेशन रजिस्ट्रार उस कोऑपरेटिव सोसाइटी से ले सकता है टू दैट एक्सटेंट, तो वो शेयर की जा सकती है, नॉट बियॉन्ड दैट। इस पे भी हम लोग बातचीत करेंगे। तो आप जो इंफॉर्मेशन ले सकते हैं, इसका मतलब हर पब्लिक अथॉरिटी से ले सकते हैं। एक क्वेश्चन ये भी सोल्व हो गया हमारा, जो बात जो है मोनू जी कह रहे हैं। हाँ जी बताइए।
जो सेल्फ फाइनेंस है वो तो बाध्य नहीं है ना सर देने को?
नहीं, सेल्फ फाइनेंसिंग बाध्य नहीं है, लेकिन मान लीजिए कोई सेल्फ फाइनेंसिंग इंस्टीट्यूशन है और यूनिवर्सिटी जो है वो कंट्रोल्ड बाय है। सपोज सम कॉलेज इज एफिलिएटेड टू भगत फूल सिंह महिला विश्वविद्यालय।
यस सर।
कोई कॉलेज है सेल्फ फाइनेंसिंग का कॉलेज है, एफिलिएटेड भगत फूल सिंह महिला विश्वविद्यालय से, जितना इंफॉर्मेशन भगत फूल सिंह महिला विश्वविद्यालय किसी कानून के तहत उनसे ले सकता है, उतनी इंफॉर्मेशन जो है आप सिटीजन अंडर राइट टू एक्ट जो है वो यूनिवर्सिटी से ले सकता है, क्योंकि वो यूनिवर्सिटी के पास आ गया इंफॉर्मेशन। लेकिन उससे ज्यादा
यूजीसी की ग्रांट भी आ रही है ना सर, वो भी दे सकते हैं अगर वो सेल्फ फाइनेंस भी है। अगर ग्रांट
है नॉन गवर्नमेंट, देखिए अगर नॉन गवर्नमेंट ऑर्गेनाइजेशन है सब्सटेंशियली फाइनेंस्ड, वहां बात उठेगी फिर यही बात तो मैडम रेनू कह रही हैं कि भाई अगर सब्सटेंशियली वो फाइनेंस्ड है वो इंस्टीट्यूशन तो आप ले सकते हैं। लेकिन अगर सब्सटेंशियली का मतलब है एक लार्ज प्रोपोर्शन में, मेजर प्रोपोर्शन ग्रांट्स का वो वहां से आता है, राइट। ऐसा नहीं है कि माइनर प्रोपोर्शन या 10% या 5% ग्रांट देते हैं, लेकिन अगर 70% ग्रांट है, 65% है, ऐसे में आप नॉन गवर्नमेंट ऑर्गेनाइजेशंस की भी पूरी इंफॉर्मेशन जो आप किसी सरकारी ऑर्गेनाइजेशन से ले सकते हैं, पब्लिक अथॉरिटी से ले सकते हैं, तो वो भी एक पब्लिक अथॉरिटी मानी जाएगी, राइट।
जैसे सर कोई प्राइवेट यूनिवर्सिटी होती है, जैसे ये
प्राइवेट यूनिवर्सिटी के ऊपर आपको मालूम है कि हर स्टेट में एक डिपार्टमेंट ऑफ हायर एजुकेशन होता है। जितनी इंफॉर्मेशन डिपार्टमेंट ऑफ हायर एजुकेशन उनसे ले सकता है, तो वही इंफॉर्मेशन जो डिपार्टमेंट ऑफ हायर एजुकेशन के पास आ गया है उसको आप एक्सेस कर सकते हैं। ऐसा थालापल्लम सोसाइटी में कहा गया सुप्रीम कोर्ट के द्वारा। ठीक है जी, अब आगे बढ़ा जाए।
यस सर,
यस सर, यस।
अब मैं
सर,
हाँ जी,
एक्सक्यूज मी, अभी आपने क्या आंसर दिया प्राइवेट यूनिवर्सिटीज वाला? मतलब मैंने सुना नहीं, सॉरी।
कोई नहीं मैम, वेलकम। जितनी इंफॉर्मेशन डिपार्टमेंट ऑफ हायर एजुकेशन और ऑफिस ऑफ द चांसलर गवर्नर, जितना इंफॉर्मेशन वो वहां से ले सकते हैं अंडर द लॉ ऑफ द प्राइवेट यूनिवर्सिटीज एक्ट, जो कानून पास किया है वो किया है प्राइवेट यूनिवर्सिटीज एक्ट वो जो कानून पास किया उसके तहत जितना इंफॉर्मेशन वो ले सकते हैं उस यूनिवर्सिटी के, वो इंफॉर्मेशन आप ले सकते हैं, क्योंकि वो पब्लिक इंस्टीट्यूशन के पास आ जाएगी वो इंफॉर्मेशन. दैट विल कम टू द गवर्नर ऑफिस, सेक्रेटरी टू या डिपार्टमेंट ऑफ हायर एजुकेशन. सो दैट इंफॉर्मेशन which the private institution is bound to supply under a legislation to a public authority. So up to that extent you can extract the information under right to information. वहां तक आप ले सकते हैं, राइट. ऐसा हालांकि सोसाइटी का एक केस है, सुप्रीम कोर्ट ने उसमें कहा है, राइट. अब हम लोग आगे चलते हैं. और
सर एक डाउट है.
प्लीज सर.
Sir, private institution which is in minority, if it is a minority private institution.
Balram wants to ask something, sir.
Yes. I will welcome after it.
Minority private institution, can they neglect RTI? They say as we are not bound by RTI, affiliated by University of Mumbai or University of any. But if it is private and minority, can they neglect it?
That is what I told you. Now, suppose it's a minority educational institution. Now, minority educational institutions will also take affiliation. Affiliation is always granted under a University Act. Now, what are the conditions for what are the conditions for grant of affiliation? What information has been sought by the affiliating university from the minority educational institutions? Those informations you can seek. If that minority educational institution is substantially financed by the government, suppose 95% grant has been given to a minority educational institution by a particular government, then it becomes.
But if it is not financed,
if it is not financed, only to that extent to which the affiliating university can seek information from that institution, not beyond it.
Okay, sir. Thank you.
Right. Welcome. Yes, बलराम जी कुछ पूछ रहे थे.
Sir, मैं ही था बलराम.
Okay, no issue. Thank you.
So it was me only.
Okay. No issue. Welcome. अब देखिए, मैं दोबारा से जो है, I will again request any other participants. अभी मैं लॉ पे नहीं जाऊंगा क्योंकि अभी हम बेसिक बात कर रहे हैं. लॉ वालों पे भी जाऊंगा, बाद में जाऊंगा सबसे बाद में, राइट. वहां पे भी चलेंगे. First, let us go to non-law subjects teachers. Yes. और कोई जोगिंदर जी भी मेरे साथ हैं, ज्योग्राफी के जो टीचर हैं. जोगिंदर जी आवाज सुन पा रहे हैं? क्योंकि अध्यापकों में भी ये भी रहता है भाई, जैसे बंक मारते हैं ना बच्चे, ऐसे अध्यापक भी बंक मार सकते हैं. ये सबका ये भी राइट है. इसको हम ये नहीं कह सकते कि वो जो है, क्योंकि एजुकेशन में
वर्चुअल मोड का साइड
फ्रीडम बहुत जरूरी है.
वर्चुअल मोड का साइड इफेक्ट
हो सकता है. तो जो है ज्योग्राफी को हो सकता है, ये हमें नहीं मालूम कि कभी पृथ्वी हिलने वाली हो, जोगिंदर जी वहां लगे हों, वो बहुत इंपॉर्टेंट काम हो सकता है हमारे से भी. So you never know, right? So you may be busy in some other assignments. So we, right? तो चलिए देखते हैं.
सर मैं बताऊं पवन सर, ये सिर्फ ऑनलाइन का साइड इफेक्ट नहीं है. ये HRDC में जितने भी बच्चे चाहे ऑफलाइन में आए चाहे ऑनलाइन में आए, ये सब बच्चे ही है.
राइट, बिल्कुल.
ये जब ऑफलाइन मोड में भी हमारे पास आते हैं ना, तब भी ये बच्चों जैसा ही बिहेव करते हैं.
वैसे कोई बात नहीं, मैं उसको बुराई नहीं मानता हूँ, अच्छी बात है. कई बार क्या होता है,
बुराई नहीं मानते सर.
हाँ जी मैम. देखिए कई बार क्या होता है कि व्यक्ति जो है, सपोज someone is not interested, we never know what is going in our brain at one point of time, our mind. So we may not be happy at a particular moment. So there is nothing wrong if someone who can go on a stroll, walk, और for a cup of tea or coffee, अगर वो लेकर आता है, उससे उसका मेंटल हेल्थ अगर ठीक रहता है तो वो भी that is not harmful, right? मेंटल हेल्थ का होना बहुत जरूरी है. अगर वो हिल गया तो that may be more harmful. इवन क्लास में भी है, अगर वो हेल्थ ठीक नहीं है तो ठीक नहीं है समाज के लिए. तो इसलिए मैं उसमें कोई ज्यादा बुरा नहीं मानता हूँ उस बात का. चलिए अब हम लोग कुंवर हंसदा अगर मैं इफ आई एम रॉन्ग प्लीज एक्सक्यूज मी. कुंवर जी.
यस सर.
या प्लीज आप भी शेयर कीजिएगा. व्हाट डू यू नो अबाउट आरटीआई अपार्ट फ्रॉम व्हाट वी डिस्कस्ड टिल नाउ, क्योंकि हमारा उद्देश्य यही है कि कुछ कुछ जाने और कुछ आपको भी पहचाने. यस प्लीज.
ये सर, ये प्रोग्राम हमें इसलिए पार्टिसिपेट किया है, आपको वैल्यूएबल जो मैसेज है सीखने के लिए.
हाँ, that is true. But what I just wish to know what you know about RTI.
दादा आपसे ये पूछ रहे हैं कि आरटीआई के बारे में आपको क्या जानना है. आपका कोई सवाल है? आपको क्या समझ में आया जो सर ने पढ़ाया?
नहीं, कोई आप ये बताइए मुझे, आरटीआई में वट एवर वी डिस्कस टिल नाउ, अपार्ट फ्रॉम दैट व्हाट यू हैव हर्ड, कुछ सुना है या पढ़ा है इससे संबंधित?
सुना है सर.
हाँ, प्लीज शेयर दैट. व्हाट यू हैव हर्ड, प्लीज शेयर दैट.
ये सर, कोई एग्जाम, कोई स्टूडेंट कोई एग्जाम देने के बाद उसका मार्क्स कम हो जाता है तो उसे आरटीआई करना पड़ता है.
थैंक यू. देखिए, दिस इज वन ऑफ द ब्यूटीफुल थिंग्स एंड हाउ वी से, बिकॉज इन केस ऑफ यू सी बंदोपाध्याय case, there is a case, CBSE versus Bandyopadhyay. So this was the contentious issue, right? वहां बंदोपाध्याय में क्या था कि some students, those who were doing chartered accountancy exam, तो वो Institute of Chartered Accountant of India से they wish to know their score, the copy answer sheet, they wanted to see it. और ये बहुत एक it has given to a bulky judgment. तो वहां से एक जजमेंट आया और बहुत अच्छा इन्होंने कहा है बात को. और वहां इंडियन इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंसी ने कहा कि लुक, वी हैव आवर ओन रूल्स, दे डू नॉट परमिट दैट वी डिस्क्लोज द आंसर शीट, राइट? तो ये एक्ट जो है, तो इस एक्ट को गया सुप्रीम कोर्ट ऑफ इंडिया, वेंट थ्रू दिस एक्ट. तो जब वो एक्ट को गया, when they went through this act, so they referred to a particular clause, right, of this particular act. And what this act, they referred to section 22 of this act. Or section 22 of this act I am going to read to you, right? देखिए कितना अच्छा बात जो है इन्होंने बताया है. वो छोटी सी बात से हमें बहुत सारी बातें हैं we will come to know, right? And I will be discussing, because it was discussed in detail by the court, that how and what, because there were other queries also. They wish to know the examiner's name, particulars of the examiners. So that was also another question there in Bandyopadhyay case. Right? So we will discuss all those issues. तो सेक्शन 22 में जब वहाँ इंडियन चार्टर्ड अकाउंटेंसी ऑफ इंडिया ने कहा कि भाई हमारा जो बाई लॉ है, बाई लॉ का मतलब जो इंडियन चार्टर्ड अकाउंटेंट ऑफ इंडिया एक्ट है, उसके तहत जो उस सोसाइटी को कानून बनाने का जो पावर दिया गया था, लाइक यू ऑल नो द यूनिवर्सिटीज एक्ट आर पास्ड बाय द ईदर सेंट्रल by the Parliament of India or maybe by the legislature of a state, like Bhagat Phool Singh Mahila Vidyalaya. It was established by Bhagat Phool Singh Mahila Vidyalaya Khanpur Act 2006 by an act of the legislature of Haryana, right? Same way, the University of Delhi or Jawaharlal Nehru University in New Delhi, they have been passed by the legislation of the Parliament of India, right? That is why they are known as central institutions and we are known as the state institutions, right? Now, when this particular thing was told that look, we have been empowered by the act to make our bylaws or rules, and we have made it a rule that the score, or what we'd say, those who have failed, their score will not be made out, and none can see one's answer sheet. This was the reply there, that these are our bylaws, right? Now, Section 72 of this particular act was referred then, and the heading title of this particular section is Act to have overriding effect. It says the provisions of this act shall have effect notwithstanding anything inconsistent contained in the Official Secret Act 1923 and any other law for the time being in force or any instrument having effect by virtue of law other than this act. What it says, that this act will prevail over other acts, right? When it will prevail over acts, it means Indian Chartered Accountancy Act will be prevailed over. And when act will be prevailed over, such laws, bylaws which are made under that act, of course it will prevail over them also. And the court says the student, that student is entitled to get one's answer sheet. They are entitled to see their answer sheet, to seek a copy, certified copy of the same. Of course, it was stated that if there is no provision of revaluation, RTI cannot facilitate revaluation. RTI is not an instrument which will say that you go for revaluation. That your law will decide whether you want one institutions allow revaluation or not. That is not the ambit of the RTI. RTI ambit is only to ensure that the information which is held by or under a public authority, that is made available to a citizen, right? This was the answer which was given in that case, right? So I will discuss the other aspects also of that particular case. It's very nice query which was asked and replied, right? On the basis of which we could know something, right? Now I am going to go to Mangal Singla ji. Yes, Mangal ji. आपका माइक जो है सर वो अभी जो है म्यूट है. हाँ
हेलो. आरटीआई एक्ट बेसिकली जो है हमारे सेंट्रल गवर्नमेंट ने अपनी एक्टिविटीज में ट्रांसपेरेंसी लाने के लिए बनाया और रिस्पॉन्सिबिलिटी जो ऑफिसर्स अपॉइंटेड है उनकी रिस्पॉन्सिबिलिटी और अकाउंटेबिलिटी को शो करने के लिए बेसिकली जो है आरटीआई एक्ट को बनाया गया है.
और क्या जानते हैं मंगल जी आप? ये भी बात बिल्कुल है, इस पे भी चर्चा करेंगे.
सॉरी सर.
हाँ जी, और भी कुछ आप जो आरटीआई के बारे में जानते हैं कुछ बताना चाहेंगे?
सर मैं थोड़ा सा ये जानना चाहूंगा आपसे, बताना तो नहीं सर, जानना चाहूंगा, सॉरी टू से, कि जैसे कॉलेज में सर हम 10 या 12 लोग हैं और हमारे यहाँ पर डॉक्टर दिनेश हैं, वो हिस्ट्री डिपार्टमेंट से हैं, बट उन्होंने एलएलबी और एलएलएम भी कर रखा है. ही इज एन एडवोकेट. तो उनको उनके पास सर आरटीआई का चार्ज है, जो भी लेटर्स वगैरह जवाब देने होते हैं. तो लेकिन अगर सर उनकी ट्रांसफर हो गई और हम लोग कोई भी जो है ना आरटीआई के बारे में, या हम तो एडवोकेट नहीं है लेकिन डीजीएचसी की तरफ से बहुत सारे ऐसे लेटर्स आते हैं सर जिनका जवाब देना होता है, तो फिर हम उसमें हमें क्या करना चाहिए? क्या हमें आरटीआई एक्ट को, लॉ को पूरे अच्छे से पढ़ करके क्या हम उनका जवाब दे सकते हैं सर?
बहुत अच्छी बात है. देखिए आपने बहुत अच्छे सवाल भी काफी आपने अच्छा पूछा है, जो कि प्रैक्टिकल एक क्वेश्चन है कि कॉलेज में जब आप सर्विस कर रहे हैं, एक बस मैं जानना, डीजीएचसी से आपने कहा है तो नेचुरल सी बात है कि आप हरियाणा के कॉलेज में काम कर रहे हैं, राइट? तो देखिए मैं आपसे वंस आई कम टू डिस्कस विद यू, तो देखिए मैं एक बात जो इन्होंने कही है पहले उस पर चर्चा करूंगा और फिर रिप्लाई करूंगा. सबसे पहले तो इन्होंने कहा है कि भाई व्हाई आरटीआई एक्ट हैज बीन इनेक्टेड. नो डाउट इट इज ट्रू. जब आप आरटीआई एक्ट 2005 का प्रीएम्बल देखते हैं, व्हेन यू गो थ्रू द प्रीएम्बल ऑफ दिस एक्ट, तो हमें पता लगता है प्रीएम्बल ऑफ एन एक्ट को हम ये कहते हैं इट इज ए की टू ओपन द माइंड ऑफ द मेकर्स ऑफ एन एक्ट. ऑल्दो वो कोई मदद में नहीं आता है, प्रीएम्बल का कोई विशेष महत्व नहीं है, लेकिन ऐसी परिस्थिति जब आपके कोई जो प्रोविजंस है अगर उसमें कोई एम्बिग्युइटी है, कोई क्लियरिटी चाहिए, तो इट कैन रिफ्लेक्ट लाइट ऑन दैट प्रोविजन. तो प्रीएम्बल की जब हम बात करते हैं तो ये एक्ट का जो प्रीएम्बल है ये कहता है दैट टेल्स दैट एन एक्ट टू प्रोवाइड फॉर setting out practical regime of the right to information for citizens to secure access to information under the control of public authorities in order to promote transparency and accountability in the working of every public authority. The constitution of a Central Information Commission and State Information Commission and for the other connected matter incident thereto. Right? अब ये कहता है कि भाई देखिए कॉन्स्टिट्यूशन का जो आइडियाज था, जो वैल्यूज था, the values were that the democracies where citizens should be informed in order to promote that there is no corruption, in order to promote those ideals, those values. पार्लियामेंट ऑफ इंडिया ने ये लेजिस्लेशन किया है कि जो पब्लिक अथॉरिटीज हैं उनका ट्रांसपेरेंसी और अकाउंटेबिलिटी के लिए, राइट, सिटीजन्स को राइट देने के लिए, उनको अवेयर करने के लिए। एक बात तो ये है। अब दूसरी बात जो इन्होंने कही कि भाई इनके यहाँ एक सहयोगी हैं, एक्स, नाम नहीं लूंगा, डॉक्टर तो हम एक्स कहते हैं, वो जो है वो लॉ ग्रेजुएट हैं, लॉ पोस्ट ग्रेजुएट हैं और अभी एक्ट के अंदर उनको कुछ जिम्मेदारी दी गई है। तो सबसे पहले जान लेते हैं कौन सी जिम्मेदारी इस एक्ट के तहत दी गई है और क्यों दी गई है। क्योंकि ये कहता है सेक्शन 4 इस एक्ट का कि भाई जो सेक्शन 6 वो ये कहता है, 4 पे भी मैं आऊंगा, वो ये बोलता है कि एवरी पब्लिक अथॉरिटी तो हमने जान ही लिया, हु इज द पब्लिक अथॉरिटी, तो कहता है एवरी पब्लिक अथॉरिटी shall within 100 days of the enactment of this act, आपको सालों हो गए हैं, दिन तो पहले 100 दिन के अंदर हर पब्लिक अथॉरिटी को, मतलब हर पब्लिक अथॉरिटी का एक ड्यूटी लगाया गया है सेक्शन 5 में, that to designate as many officers as central public information or state public information officer as the case may be in all administrative unit or offices under it as may be necessary to provide information to persons requesting for the information under this act. कहते हैं हर पब्लिक अथॉरिटी को एक डेजिग्नेट करना है, एक व्यक्ति को या कई व्यक्तियों को, अगर उसकी कई एडमिनिस्ट्रेटिव यूनिट है तो, या एक पब्लिक सेंट्रल पब्लिक इंफॉर्मेशन, इफ इट इज ए सेंट्रल पब्लिक अथॉरिटी एस्टैब्लिश्ड बाय द गवर्नमेंट ऑफ इंडिया, वहां से फाइनेंस होता है तो ऐसी जगह सीपीआईओ होगा, और जो स्टेट से होता है वहां जगह एसपीआईओ होगा, स्टेट पब्लिक इंफॉर्मेशन ऑफिसर, वो डेजिग्नेट करना है। और कहा है एवरी पब्लिक अथॉरिटी शैल डेजिग्नेट एन ऑफिसर एट ईच सब डिवीजन लेवल और सब डिस्ट्रिक्ट लेवल एज सेंट्रल असिस्टेंट पीआईओ और स्टेट एसपीआईओ, वो मदद करने के लिए है, राइट, एसपीआईओ की। अब यहाँ एक ड्यूटी लगाई गई है, हर पब्लिक अथॉरिटी को एक एसपीआईओ या सीपीआईओ का अपॉइंट करना है, और उसकी मदद के लिए एक जो है सेंट्रल असिस्टेंट पब्लिक इंफॉर्मेशन ऑफिसर या स्टेट असिस्टेंट पब्लिक इंफॉर्मेशन ऑफिसर, वो उसको अपॉइंट करना है। ऐसा ड्यूटी लगाया गया है। अब ये ड्यूटी जो लगाई गई, वो जो ड्यूटी एक कॉलेज की भी है, बिकॉज इट इज ऑल्सो ए पब्लिक अथॉरिटी, वो भी एक कानून के तहत है, गवर्नमेंट ने नोटिफिकेशन के तहत है, फाइनेंस्ड है। अब वहां इनके यहाँ जो प्रिंसिपल महोदय हैं, उन्होंने जो मिस्टर एक्स हैं, जो लॉ ग्रेजुएट और पोस्ट ग्रेजुएट हैं, दैट मिस्टर एक्स हैज बीन डेजिग्नेटेड एज एसपीआईओ, और वहां के किसी सुपरिटेंडेंट को या क्लर्क को या असिस्टेंट को जो है एक, या उनके किसी सहयोगी को, जूनियर को, किसी को असिस्टेंट एएसपीआईओ जो है उनको अपॉइंट किया गया। बिल्कुल सर। तो ऐसी स्थिति में वो व्यक्ति जो लॉ ग्रेजुएट है, वो नेचुरल सी बात है कि वो व्यक्ति इस एक्ट से अवेयर है, तो वो इजीली डिस्चार्ज कर सकता है। जब हरियाणा की बात करते हैं तो 2018 में द चीफ सेक्रेटरी ऑफ हरियाणा, दे हैव केम आउट विद ए नोटिफिकेशन, जिसमें ये कहा है कि एवरी पब्लिक अथॉरिटी इन हरियाणा विल डेजिग्नेट ए एसपीआईओ एन ऑफिसर नॉट बिलो होल्डिंग द पोस्ट इन क्लास बी। ये कहा भी कोई भी एक ऐसा अधिकारी जो कम से कम क्लास बी, ज्यादातर क्या हो गया था हरियाणा में, जब ये आरटीआई आया तो बहुत सारे इंस्टीट्यूशंस ने व्हाट दे डिड, उन्होंने क्लास सी का जो क्लर्क है या असिस्टेंट है उनको एसपीआईओ बना दिया। और वो वहां जाते अपील में। अब उनका जो अवेयरनेस लेवल है, जब क्लास की पोस्टिंग दी जाती है तो नेचुरल सी बात है कि आपका क्वालिफिकेशंस हैज टू बी टेकन इनटू कंसिडरेशन। तो उसमें क्या हुआ कि वो दे वर नॉट एबल टू रिप्लाई टू द फर्स्ट अपेलेट अथॉरिटी और स्टेट सेकंड अपेलेट अथॉरिटी। फर्स्ट में तो खैर ज्यादा नहीं असर पड़ेगा, लेकिन जब वो स्टेट इंफॉर्मेशन कमीशन में गए SIC में, और इसी तरह से जो सेंट्रल गवर्नमेंट है वहां CIC में गए, तो SIC और CIC ने ये ऑब्जर्व किया कि बहुत लो ग्रेड के जो ऑफिशियल्स हैं उनको SPIO डेजिग्नेट किया गया है, और विच इज क्रिएटिंग हिंड्रेंस रेदर देन फैसिलिटेटिंग द RTI। तो ये एक डिसीजन लिया गया गवर्नमेंट के लेवल पर कि भैया हरियाणा में खास तौर पर मैं बता रहा हूं, हालांकि सेंटर में भी CIC ने एक डिसीजन लिया कि नॉट बिलो द रैंक ऑफ द अंडर सेक्रेटरी जो है कम से कम आप फर्स्ट अपेलेट अथॉरिटी लगाएंगे। इसी तरह से कहा गया क्लास A का जो अधिकारी है वो कम से कम फर्स्ट अपेलेट अथॉरिटी हो, और क्लास B का जो अधिकारी है वो जो है SPIO हो, ऐसा कहा गया। ये भी हुआ बहुत सारे केसेस में, जैसा इन्होंने बताया मंगल सिंगला जी ने, कि सेक्शन 5 भी बोलता है कि बहुत सारी ब्रांचेज हैं वहां SPIO लगाइए। हमारे यहाँ भी देयर वर 31 SPIOs। जब मुझे फर्स्ट अपेलेट अथॉरिटी लगाया गया, एक जिम्मेदारी दी गई, तो 31 SPIOs थे। तो 2019 में एक जो है सुप्रीम कोर्ट की कॉन्स्टिट्यूशन बेंच के सामने, 5 जजेस बेंच के सामने, देयर वर 5 जजेस बेंच which was constituted in case of CPIO, Central Public Information Officer versus सुभाष चंद्र अग्रवाल। ये पहला दुनिया में मतलब दूसरा केस है जब सुप्रीम कोर्ट में अपील कर रहा है, राइट। ये ऐसा केस था, और वो क्यों हुआ उस पर भी हम लोग बातचीत करेंगे। अभी कुछ दिन पहले, few days back, there was a workshop which was organized by the Department of Law in this university, and सुभाष चंद्र अग्रवाल जी जो है वो हमने बुलाए हुए थे, तो वो he was telling all these things, जो मैं आपके साथ भी शेयर करूंगा कुछ बातें। तो उस पर्टिकुलर केस में एक क्वेश्चन ये उठा कि भाई सुप्रीम कोर्ट में जो सुप्रीम कोर्ट का SPIO है, क्या चीफ जस्टिस ऑफ इंडिया का SPIO अलग होगा या चीफ जस्टिस ऑफ इंडिया के ऑफिस का SPIO और सुप्रीम कोर्ट के ऑफिस का SPIO सिंगल होगा? एक ये बात, दिस वाज वन ऑफ द इश्यूज, वेदर द चीफ जस्टिस ऑफ इंडिया ऑफिस विल हैव ए सेपरेट CPIO, सेंट्रल पब्लिक इंफॉर्मेशन, अपार्ट फ्रॉम द CPIO ऑफ द सुप्रीम कोर्ट ऑफ इंडिया। तो वहां ये कहा गया है कि सुप्रीम कोर्ट ऑफ इंडिया इज ए सिंगल इंस्टीट्यूशन, देयर मे बी एवरी जज मे हैव इट्स ओन सेक्रेटरिएट। हर जज का अपना सेक्रेटरिएट हो सकता है, उसका अपना रीडर हो सकता है, लेकिन एज एन इंस्टीट्यूशन द सुप्रीम कोर्ट ऑफ इंडिया इज ए सिंगल एंटिटी, एंड दैट इज व्हाई देयर विल बी ए सिंगल SPIO। ऐसा डिसीजन जो है ये आया 30 नवंबर 2019 को। तो मुझे यहां जब जिम्मेदारी दी गई तो मैंने कहा देखिए सेक्शन 5 क्लॉज 4 वो ये कहता है कि स्टेट पब्लिक इंफॉर्मेशन ऑफिसर और स्टेट पब्लिक इंफॉर्मेशन ऑफिसर एज द केस में बी, CPIO और SPIO एज द केस में बी, may seek assistance of any other officer as he or she may consider necessary for proper discharge of his or her duties। एक तो ये बात है, और दूसरा सेक्शन 6 सबसेक्शन 3 वो ये कहता है that where an application is made to a public authority requesting for an information which is held by another public authority, or the subject matter of which is more closely connected with the function of another public authority, the public authority to which such application is made shall transfer the application or such part of it as may be appropriate to that public authority and inform the applicant immediately about such transfer। ये कहा गया पब्लिक अथॉरिटी को कोई सूचना मांगता है वो सूचना मेरे विश्वविद्यालय से संबंधित नहीं है, तो उसको पब्लिक अथॉरिटी ट्रांसफर करेगा ऐसी अथॉरिटी को जिसके पास वो सूचना हो सकती है या संभावना है होने की, और 5 दिन के अंदर अंदर ये कार्य करना पड़ता है सेक्शन 6 सब सेक्शन 3 के अनुसार। Within 5 days, once you receive an information, if it doesn't relate to your organization, that information, the SPIO or CPIO as the case may, is under an obligation, is under a duty to transfer that application or that point of an application which does not relate to your organization to such an organization to which it relates, और जैसा उससे कनेक्टेड हो, जैसा आपको लगे। तो इस केस में तो मैंने कहा भाई सेक्शन 6 क्लॉज 3 में आप आउटसाइडर को ट्रांसफर कर सकते हो, सेक्शन 5 क्लॉज 4 में आप असिस्टेंस प्रोवाइड सीख कर सकते हो किसी भी से विद इन एन ऑर्गेनाइजेशन। तो मैंने हमारे यहाँ भगत फूल सिंह महिला विश्वविद्यालय में अथॉरिटीज को रिक्वेस्ट किया कि आप एक सिंगल SPIO लगाइए। कारण क्या था? कारण कई थे। एक कारण ये था कि जब सेकंड अपील होती थी तो आप सभी को मालूम है जो हरियाणा से रहने वाले हैं, ऑल दोज हु आर रेजिडेंट ऑफ हरियाणा participants, they know that our state information commissioners, they sit at Panchkula, rather Chandigarh, not Panchkula, sorry. And Chandigarh is 220 kilometers from the place where I am sitting. 4 or 5 SPIOs, because every, like we have establishment branch, college branch, academic branch, exam branch, journal branch, HRDC, law department, ITTR, there were multiple. Every unit has appointed its own SPIO. It was by order of the competent authority. And if there is an information, suppose there are 31 points, one point belongs to one SPIO, another point belongs to another SPIO. 31 SPIOs used to reply. 31 post orders used to go. We used to block the postal highway. Same way, when there is a second appeal before the Chandigarh, 31 people will go. A bus contingent of bus will go, or a taxi will go with 7 officials. Suppose the students has to come to the exam branch, you will find that there is SPIO. SPIO is missing. And who is SPIO? The concerned branch superintendent is SPIO. You can't appoint someone below the class B. And there are limited class B officers in our university. So what I find when I wrote a paper also, which was published in University of Delhi, National Law University Delhi. So what I find that there is a wastage of working hours, wastage of public money. So I requested the university authority at that time, Professor Sushma Yadav. It took me 2-3 months to convince them. And we were successful in having one SPIO. And you will be surprised. RTI applicants, they were very happy. Otherwise, what used to happen, 31 letters used to come. They used to compile. They used to see whether which point belongs to whom, which information has been supplied. So it becomes very easy for them. For us, only one registry will go instead of 31 registries. He collected, right? So it becomes very easy. Although my next target is, I am thinking that in our university website, there must be a column. We are thinking, next period of time. When we talk about digital India, our Prime Minister talk about digital India. So how we will inform it, how we will do it. We are insisting, most of the RTI applicant, when they come to hearing for first appeal before me, we have made a column there for email. That what is your email ID? If they provide email ID, we inform, you will receive the information through the email. Right? So that it is convenient to him as well as us. I am thinking very soon we will have a separate allocated space where digital signatures of the SPIO will be available, and those persons will be supplied the information bearing digital signatures. So it will further bring down our expenses, right? So we are working on that. So same way, now I come to the question, whether law graduate or law postgraduate is mandatory. That is not mandatory under RTA. But it is convenient if the person is aware about law, if the person, and that is why, although in our law, there is one thing. That saying is, and that should be for everyone also, I would say. Although it may be dangerous also, I am not saying that it is universally truth. So please don't take it in letter and spirit. लेकिन हमारे यहाँ एक saying है that a lawyer should know something of everything rather than knowing everything about something. Why it is so? क्योंकि हमें ये माना जाता है, मेरे teachers used to say, if a lawyer know everything of something, then that person will not be a lawyer. वो फिर सिंगर होगा, एक्टर होगा या कोई दूसरा प्रोफेशन करेगा. इसी तरह से टीचिंग में भी मेरा ये मानना है that what we presume as a student of law, मुझे बहुत मतलब मैं आपके साथ शेयर कर रहा हूं आज एक बात. मेरे 2, 3, 4 स्टूडेंट माय फ्रेंड्स, हम लोग बेंच पर बैठते थे. So 3 of my friends in very close proximity which used to sit, और इसमें से 1-2 तो जानते हैं आप में से पार्टिसिपेंट, वो आजकल जो है एडिशनल सेशन जज. तो अब जब हम लोग बातचीत करते थे, तो जब हम when we used to study in college, तो वो एक बात कहते थे, जब हमारे से कॉलेज में एफिडेविट मांगा जाता था तो वी वर वेरी टू गिव द एफिडेविट. भैया एफिडेविट देना है, बहुत इजी काम है, सबसे इजी काम लगता था. और जब हमने लॉ किया तो लगता भाई एफिडेविट तो इट्स वेरी वेरी, आई मीन्स ऑन ओथ यू आर सेइंग समथिंग, एंड सपोज tomorrow if it is not true, there are serious consequences for the person who is submitting that affidavit, right? तो अब ये बात मैं इसलिए भी बता रहा हूं, जब आप किसी सोसाइटी में रहते हैं, if that society is rule based society, it is very important to us to understand the rules. Otherwise it may have serious consequences on our life and liberty. We all know recently a very famous Bollywood personality's son has to forego freedom for certain days for violation of a law. So what we presume in law, that mistake of law is not an excuse. Mistake of a fact may be an excuse. You may not be aware about a fact. Everyone is not supposed to know each and every fact. But when you are living in a country which is based on a constitution, everyone is supposed to know the law of the land. That has to be there. That is what we presume. Although it is not possible that everyone understand all those 7,000 legislations. But without that, suppose I violate a law. Tomorrow, a girl at the age of 16 years, she commits some unlawful act and then say, I was not aware about this law. That will not be an excuse. Although the sentence may be less, that's true. But otherwise, how you will come to know whether she knows the law or not know? Because that is something within your faculty. We can't expect that. So it is presumed that everyone should know the law. Why I am telling, especially the Right to Information Act, because it is a legislation which has been enacted to strengthen the democratic fabric of this nation, so that the public officials, the public authorities, they are made accountable, there is no corruption, right? Now I come, अब इनका जो क्वेश्चन है उसको स्पेसिफिकली आंसर करें। तो मेरा सर आपसे यही अनुरोध रहेगा कि your college should organize some workshop on RTI so that most of the faculty members they become aware। और आपके प्रिंसिपल से आप जरूर अनुरोध कीजिएगा कि वर्कशॉप ऑर्गेनाइज करें, कोई एक्सटेंशन लेक्चर करवाएं, किसी एमिनेंट व्यक्ति को बुलाएं, so that other people, your students as well as the faculty, they become engaged, right? Thank you
सर।
थैंक यू जी।
एक क्वेश्चन सर मेरा और है, आपसे एक सवाल पूछा था।
बिल्कुल, मोस्ट
वी ऑल आर गवर्नमेंट एम्प्लॉयज,
यस,
so can any outside person ask some personal information about us from our principal?
Very nice.
Like some personal information like family members, spouse or son, daughter. क्या ये इंफॉर्मेशन भी वो हमारे से मांग सकते हैं, हमारे प्रिंसिपल से मांग सकते हैं?
बहुत अच्छा।
जैसे मैं थोड़ा सा बताना चाहूंगा सर। एक्चुअली हमारे एक साथी थे, सीनियर साथी, उनका कोई डिस्प्यूट होगा कोई पर्सनल, तो किसी ने उनके ऊपर आरटीआई लगाई, कॉलेज में आरटीआई लगाई कि एक तो इनकी पर्सनल इंफॉर्मेशन हमें दीजिए, फैमिली मेंबर्स कितने हैं, बच्चे कितने हैं, हाउस कितने हैं, इन्होंने लोन वगैरह कितना ले रखा है, और एक पॉइंट में उन्होंने पूछ रखा था कि सैलरी स्टेटस भी आप मेंशन करें। तो कॉलेज ने सिर्फ सैलरी स्टेटस मेंशन करके दिया, उनकी पर्सनल इंफॉर्मेशन के लिए लिख करके दे दिया कि जो कंसर्न पर्सन है, कंसर्न जो प्रोफेसर है, वो हमें ये पर्सनल इंफॉर्मेशन उन्होंने मना कर दी है देने से। तो कॉलेज ने उनको पर्सनल इंफॉर्मेशन देने से रिफ्यूज कर दिया, सिर्फ सैलरी से रिलेटेड जो फैक्ट्स थे वो उन्होंने बता दिए।
बहुत अच्छा आपका क्वेश्चन है, जो बिकॉज यू सी एवरी ऑर्गेनाइजेशन देयर आर टू थिंग्स, देयर आर टू राइट्स which are being tried to balance in this particular act. There is an attempt by the Parliament of India. One is right to information and accountability of the public servants or the public authority. And another is protecting the privacy, personal information of a person at the time one is working in the organization. ये बहुत ही महत्वपूर्ण जो क्वेश्चन आपने उठाया है, दिस हैज बीन रिप्लाइड बाय द सुप्रीम कोर्ट ऑफ इंडिया इन केस ऑफ CPIO वर्सेस सुभाष चंद्र अग्रवाल, which I told you, 5 judges bench, and there was it is around 250 pages judgment which has elaborated on this subject, and it has been stated there in this particular act. I will highlight that. All this bare act tells about giving information, but section 8 to 11, there are certain safeguards. Section 8, it talks about which informations are exempted from disclosure. When we go through this particular section, it starts with the non-obstante clause. Non-law teachers, they should understand what is this non-obstante clause. Non-obstante clause means this particular clause says that notwithstanding anything contained in this act, it means overriding this act, over and above this act. What this is, there shall be no obligation to give any citizen which informations, certain types of informations, they are exempted. Whatever has been said, irrespective of whatever has been said in this particular act, some categories of informations that is protected, some of them is absolutely protected, rest of them is relatively protected. Now, what is that absolute protection and what is that relative protection? We will discuss that. When section 8 1A, it says information, disclosure of which would prejudicially affect the sovereignty and integrity of India. Strategic, scientific or economic interest of the state, relationship with foreign state, leads to incitement and offense, absolute immunity. On these grounds, if the information is likely to cause a danger to the sovereignty and integrity of India, it can be refused, straightway refusal, not allowed to disclose. Strategic information, which is critical for the defense of India, for the integrity of India, for the sovereignty of India, straightway can be refused. Scientific information, not ordinary scientific information. The information which is sensitive, the information, if it falls, in the hands of such people who think to disintegrate our nation, such scientific information can be denied. Economic interest of the nation, if they are likely to be harmed. Second, information which is likely to incite an offense, straightway it can be refused. Information which has been expressly forbidden to be published by any court of law, tribunal, or disclosure of which may constitute contempt of court. Suppose in camera proceedings are going, court has told that such kind of proceedings will not be put in public. If someone publishes such information, contempt of court may be there. So such informations may not be provided. Absolute exemption. Information disclosure of which would cause a breach of privilege of Parliament or state legislature. Parliament of India has been given certain privileges. None of them I still remember, Sri Somnath Chatterjee. All of you may know him. He has been esteemed Speaker of our House of People at one point of time. Supreme Court of India has issued a contempt notice to him. And I still remember his statement when I saw the television that day. He stated that, look, Supreme Court of India as well as the Parliament of India, they were created by the same constitution. What is happening within the Parliament? It is the Speaker of the House who is authorized to act to decide on that matter. No court can take cognizance of the same, what I have decided there in the House. So I am not accountable for the acts done in the House. And he was right also. Whatever is being done within the four corners of the House of the Parliament, no court can take cognizance of that. Now, apart from that, information including commercial confidence. It means an agreement entered, such information, trade secrets, intellectual property, disclosure of which would harm the competitive position of third party. Third party means anyone except the RTI applicant and the public authority. Although even in case of public authority, if you are approached to the CPIO or SPIO as the case may be, first is you, second is SPIO. If information relates to anyone else, and one cannot provide information in one own case, one I will have to say that, look, the information has been sought against me, therefore someone else may be appointed as SPIO, then that individual will become third party. अगर third party information मांगा गया है, unless and until larger public interest satisfies, no one is bound to disclose that. Information available to a person in fiduciary relationship. Suppose you have given information to a doctor, to your employer, you are working for the welfare of your employer. Such information which has been supplied by you, what Dr. Mangal was telling, आपने information आपके employer ने मांगी कि भैया आपकी फैमिली में कितने आदमी हैं, so that if there is any problem with you, the information can be supplied to such people. You have supplied that information in a fiduciary relation to your employer. Such information cannot be shared with the third world. Suppose you have given, your employer has asked you your bank account number so that your salary may be put there. Your bank account number cannot be shared. Your employer has asked about your blood group. That cannot be shared. Your employer has asked about your weight. That information cannot be shared with anyone. Your employer has asked about your, suppose, your height. That information cannot be supplied unless and until, suppose recruitment rule provided that there should be a height of this feet at this centimeter. In that case, you will have to supply that yes, this gentleman has this much height beyond this height. Although you are not bound to supply the exact height, even then, right? Then suppose you have given details about, there are talks about, like your employer has given a memo, notices to you. None of the public can know it because it is a matter between fiduciary relationship between you and your employer, and under that trust you have been given that notice, you are replying to your employer, not to the whole world. So that cannot be disclosed. Whatever disciplinary proceedings have been taken by your employer, that cannot be shared. This has been stated by the court in many cases, like Girish Chandra Deshpande versus a particular state. There it was clearly stated by the Supreme Court that look, how many memos have been given, how many notices have been given, what has been work and conducted during a particular year of an employee, what kind of ACR are there, what kind of positions has been given here. Third world has nothing to do with that. Only if, suppose, whether the inspector is on a duty on a particular day or not, you can ask. Right? But you cannot ask that what action was taken. That is public authority will decide, right? Also, it was stated here, I would just go to section 8(1)(j), what Dr. Mangal was telling. Information will relate to personal information. And Supreme Court in this particular case says, personal information means your educational qualification. Suppose someone want to know whether what kind of percentage marks division you have in your 10th, in your 12th, in your graduation.
Educational qualification.
Yes, educational qualification. They cannot be asked unless and until. Of course, your employer can only say that, look, they fulfill the educational qualifications prescribed by the advertisement. Right? Your administrative department can seek it in case there is a complaint. Although one can say, if there is a larger public interest, it has to be disclosed. SPIO has to decide whether it is in the general public interest. It means whether it is for the welfare of the most of the people of this society. Suppose there are gross allegations that a person who has not passed graduation has been appointed to a post which prescribe the qualifications, graduation as a basic qualification. In that scenario, your authority will have to make a declaration that, look, this is not the case, right? If still there are doubts in that situation, it has to be made public, right? But there has to be inquiry first. There must be an inquiry. If there is no inquiry, even during inquiries, you cannot share information. But at the same time, there is an exception. There is a rider. Suppose employer has initiated an inquiry against me on certain facts. Without communicating those facts to me, I am entitled to go those informations under RTI also. This was laid down in many cases, in case of sexual harassment cases, where a woman, she has alleged instances of sexual harassment at workplace against the colleagues. Information was not provided to her by the employer. CIC says, no, you can't keep, you cannot provide this information to the third world, third parties. But the complainant and the person against whom complaint has been made, they are entitled to receive the information. Right? Rest of the people, they are not entitled. Right? Because larger public interest requires what? That the person against whom a complaint is made, he is in a position to defend. he has material against whatever is allegations against him or the basis of the allegations. So that is what it has been stated. Although it has been stated that if information, there are certain safeguards for the third party also. Suppose a SPIO or a CPIO, or even the first appellate authority or second appellate authority, namely the State Information Commission, the Central Information Commission. Because all of you must know that what are the machineries which has been established under this particular act. You will find that first and foremost machinery is the SPIO, that every public authority has been asked that you will appoint a SPIO. SPIO has been put under an obligation. Within 30 days, SPIO has to supply the information. Of course, SPIO can seek the prescribed application fee. It has been prescribed, like in Haryana, it is rupees 10. Central also it is rupees 10. A document fee, whatever documents you are supposed to supply under the RTI Act, you can ask for the document fee. The fee which you have, the amount which you have spent for getting the photocopies of the information, you can ask for that, so that there is no expenditure, right, on the part of the state. Although at the same time, the Act has mandated under Section 4B, certain mandatory disclosures are there. Mandatory disclosures means it is the obligation of each public authority. हर public authority का ये duty है कि वो जो है every public authority shall maintain all its record duly catalog. पूरा record होगा जो catalog होगा in a manner and form which facilitate the right to information under this Act, and to ensure that all the records that are appropriate to be computerized within a reasonable period, right, subject to the availability of resources, computerized and connected to the network over the country on different systems so that people can access it. And within 120 days, public authorities were supposed to give on the website particulars of this organization, function and duties. It means every public institution should have a website which must tell the organization what is the nature of the institution, what are the functions, what are the duties of that organization, what are the powers and duties of the officers and employees that must be available on the website. The procedure followed in decision making, how decisions are made in that university, whether there is a body like in universities, executive council, academic council, like in colleges, your staff council, right? And on which matters, including channel of supervision and accountability, how accountability is supervised, right? Rules, regulation, instructions, manual record, which are held by or under the control of a public authority, right? Then statement of the catalog, categories of the documents which are available with a, that must be there, catalog. Not every information on the website, only catalog, that these are the information available in these particular institutions. System of the boards, council, committees. So there are number of around 14 to 15 informations which are mandatory to be disclosed. Rest of the information, they are voluntary. If you want, disclose. You don't want, you may not disclose on the website. It is for every public authority, right? So when you are aware that every public and the CPIO or Public Information Officer, what I call, it may be CPIO or SPIO, within 30 days, once they receive the application, ASPIO has been told that within 5 days or 7 days, they will forward the application to the CPIO or SPIO as the case may be. They are there to help. Everyone has to help within the organization to the SPIO or CPIO as the case may be. Under Section 5, Clause 4, that is the power which is given to SPIO. SPIO has to decide whether the information need to or whether it is exempted. In case the SPIO decides that larger public interest requires that the third party information or information held, suppose it is only 81J, then SPIO has to decide. Rest of the cases, public authority has to decide whether, suppose some information which is held in a fiduciary relationship by the principal or by the employer, DHE, then it is the competent authority, and competent authority is, in case of state, it is the governor of a particular state. In case of a union territory, it is the administrator. In case of the Parliament of India, it is the Speaker, House of People, right? In case of Supreme Court, it is the Chief Justice of India. In case of the High Courts, it is the Chief Justice of every High Court. So they are the public authorities which has to decide whether a particular information is which is supplied under a fiduciary relationship, whether that need to be supplied to the third party under RTI Act. But in case of 8(1)(j, it is SPIO or CPIO which has to decide whether a personal information pertaining to a person, right, which includes the performance, which includes the evaluation reports, which includes qualifications, which includes property details. Although property details is not supposed to supply it, right? But if larger public interest requires, all these informations can be, this has to be decided by the SPIO. So SPIO has been given a very important duty to identify, to make a balance whether this information which is public, personal, need to be provided in larger public interest. If the RTI applicant has not specified any public interest, although you cannot ask why you have put the RTI application. One can put the RTI application, but one cannot ask the questions in RTI application because you are not supposed to interpret the RTI. You are not a person who has to interpret something. उसमें कोई आपने idea नहीं लगाना है. Information you are not supposed to create or generate. आपको वो जनरेट भी नहीं करना कोई इंफॉर्मेशन. द इंफॉर्मेशन विच इज देयर आपको इंडेक्स करना पड़ सकता है. आप ये बता सकते हैं पेज नंबर इतने से इतने ये इंफॉर्मेशन है, राइट. वो इंडेक्स आप बना सकते हैं बट नॉट बियॉन्ड इट. आपने कोई क्रिएशन नहीं करना है इंफॉर्मेशन का. ओनली यू हैव टू सप्लाई द इंफॉर्मेशन विच इज अवेलेबल इन द रिकॉर्ड. यू आर नॉट सपोज टू क्रिएट, टू मैनिपुलेट, टू. हाँ, अगर कोई एसपीआईओ इंटेंशनली मैलिशियसली डज नॉट प्रोवाइड द इंफॉर्मेशन तो वहां पावर दिया हुआ है कि भैया अगर वो 30 दिन में इंफॉर्मेशन सप्लाई नहीं करता है तो देयर इज अनदर अथॉरिटी दैट इज फर्स्ट अपेलेट अथॉरिटी अंडर सेक्शन 19. उसको वहां एवरी पब्लिक अथॉरिटी हैज टू अपॉइंट a officer who is superior in rank to the SPIO or CPIO as the case may be as first appellate authority. First appellate authority has to decide within 45 days, right, of the receipt of the first appeal. उसको डिसाइड करना है. इफ इट इज नॉट इन अ पोजीशन टू डिसाइड 45 days, इट हैज टू गिव द रीजंस व्हाई द अपील हैज नॉट बीन डिसाइडेड विद इन 45 days, राइट. तो फिर उसके बाद अगर इफ समवन इज नॉट सेटिस्फाइड, आल्सो वन ऑफ द ड्यूटीज ऑफ द एसपीआईओ है वो इसमें दिया हुआ है कि व्हाट आर द ड्यूटीज ऑफ द एसपीआईओ, ऑब्लिगेशंस क्या है एसपीआईओ का, पूरा चार्ट है, राइट, एसपीआईओ के बारे में कि भाई वो कैसे डिस्पोजल करेगा. सेक्शन 7 में पूरा ड्यूटी का दिया है कि भाई अगर राइट टू लाइफ या लिबर्टी से संबंधित है, किसी को जेल होने का संभावना है, कोई किसी का जीवन खतरे में है तो 48 आवर्स के अंदर अंदर भी इंफॉर्मेशन सप्लाई करने का प्रोविजन है, राइट. अदरवाइज 30 days है और जितना फीस है वो आप उनसे मांग सकते हैं, उसमें कोई इश्यू नहीं है. तो देखिए अगर कोई एसपीआईओ का ये भी ऑब्लिगेशन है, एट द टाइम ऑफ द सप्लाइंग ऑफ द इंफॉर्मेशन एसपीआईओ हैज टू मेंशन that in case you are not satisfied with the information supplied by me, you can file the first appeal within 45 days to this first appellate authority at this place. ये भी मैंडेटरी है, राइट. और उसके अलावा if someone is not satisfied with the first appellate authority decision, so that individual can file the second appeal. In case of states, it is State Information Commissioner. In case of center, it is Central Information Commissioner, right? So there are, every state has been made under obligation under this act. It is the duty of the every state government, right, by notification to constitute a body known as the State Information Commission, or we call it Information Commission. Every government, state government, and in case of central government, it is the Central Information Commission which has to be constituted by the central government. What are the powers, duties? Although there has been amendment in 2019 and it has been criticized by many, even I have written an article on that. Earlier, the terms and conditions of the appointment of the State Information Commissioner as well as the Chief Information Commissioners, they were equivalent to the High Court and Supreme Court judges. You could see the autonomy which was granted at the time of the enactment of the RTI Act in 2005, that they were treated that their terms and conditions will be equivalent to the High Court judges in case of SICs and in case of CIC Supreme Court judges, and their remuneration allowances, that was also similar to that. But in 2019 it was curtailed out, and I have condemned it, that it is an attempt to rather I would say restrict the scope of that RTI Act, because the RTI commissioners somehow they have been made dependent on the government. Rather, earlier it was not, they were not dependent on the government. When the parliament enacted that, the status of the, you see, the judges of the High Court and Supreme Court was granted to them, right? So that was a very, I would say, fantastic independence was given to them. Somehow now they have been bowed down and the state government has to define the terms and conditions, right? So that way, it's I find it as it's a way to curtail their freedoms rather than enhancing or expanding them, right? Reasons may be many. I do not want to go to those reasons, right? But the legislation has certain, it has undermined the sanctity or autonomy of the state information commissioners. Although I do not say that they are not working independently, they are working, but somehow their terms and conditions have come within the hands of the state government and the central government, right? So the persons who are not satisfied with the decision of First Appellate Authority, they can go within 90 days to the State Information Commission or State Central Information Commission, as the case may be, right? So Central and State Information Commissioners, they have been empowered that they can impose penalty 250 per day or up to 25,000 if there is a violation of this act by the SPIU or CPIU, as the case may be, right? As well as it is stated that in case of complaints, they can recommend departmental action against the SPIU or CPIU.
Notification access.
हेलो
यस सर
ओके एक्चुअली वो कनेक्शन लॉस्ट हो गया था यूनिवर्सिटी से, तो अभी पावर डाउन हो गया था, तो आई हैव जस्ट जॉइंड यू टू द मोबाइल।
जी सर,
अभी आप लोगों का अगर कोई डाउट है तो आई एम रेडी टू एक्सप्लेन। एनी पार्टिसिपेंट क्वेरी?
I think, sir, you have already answered so many questions during your session.
Most welcome.
Very, very elaborative session. आपने एक एक पॉइंट के ऊपर इतने अच्छे से सारे केसेस को डिस्कस करते हुए इनके डाउट्स क्लियर करे हैं, इनको इतना अच्छा एक्सप्लेन किया है, और बीच बीच में आपने सभी के डाउट्स भी ले लिए और उनकी क्वेरीज भी आपने पूछी, उनका समाधान भी दिया। It was thoroughly enjoyable session for all of us. फिर भी अगर किसी को अभी भी कोई डाउट है तो आप पूछ सकते हैं, और मैं सबका धन्यवाद करना चाहूंगी और सर का खास तौर पे धन्यवाद करना चाहूंगी कि उन्होंने बहुत ही अच्छा सेशन जो है इस आरटीआई के ऊपर लिया है। हमारे बहुत सारे डाउट्स, बहुत सारी नॉलेज, बहुत सारी अवेयरनेस जो आपने क्रिएट करी है, और सबसे अच्छी बात थी कि आप हमें समाधान भी साथ साथ बताते जा रहे थे प्रॉब्लम्स के, कि हम किस तरह से इसको अपने इंस्टीट्यूशंस में लागू कर सकते हैं, किस तरह से इंडिविजुअल को और किस तरह से इंस्टीट्यूशंस को इसके साथ करना चाहिए, और कैसे इसकी रिस्पेक्ट हम कर सकते हैं इस एक्ट की, ये भी आपने हमें बहुत अच्छे से बताया। वी आर इंडीड वेरी थैंकफुल टू यू। सो मे आई रिक्वेस्ट मंगल जी टू प्रेजेंट अ वोट ऑफ थैंक्स टू सर।
बहुत अच्छा सेशन रहा सर का मैम, और आई स्पेशली थैंक्स टू डॉक्टर पवन फॉर गिविंग अस सो मेनी आइडियाज अबाउट द आरटीआई एक्ट एंड हाउ टू इम्प्लीमेंट इन आवर सर्विस। और एक बात सर मुझे आपकी जो बहुत अच्छी लगी वो ये कि हम अपनी ड्यूटी से तो नहीं बच सकते, हाँ, हम उनको सीख करके उस ड्यूटी को अच्छे से निभा सकते हैं। कि आपने कहा कि यदि वो मेरे कुलीग अगर वो यहाँ से ट्रांसफर हो गए तो वो ड्यूटी किसी को भी मिल सकती है, तो ड्यूटी से नहीं बचना है, एक्ट को सीखना है ताकि वो ड्यूटी इजीली परफॉर्म की जाए। दूसरा सर, मुझे और क्लियर हुआ कि पर्सनल इंफॉर्मेशन देने के लिए कोई लाइबिलिटी नहीं है। हालांकि एसपीआईओ की जो है कुछ डिस्क्रिशनरी पावर है, जिनके बेस पर जो है वो रेशनल डिसीजन ले सकता है वेदर दिस इंफॉर्मेशन इज बीइंग सेंट टू द पर्सन और नॉट, या किसी व्यक्ति को दी जाए या नहीं दी जाए। सेकेंडरी, जिस डिपार्टमेंट में हम काम कर रहे हैं, सपोज वी आर द पर्सन हु आर वर्किंग अंडर द DGHE, डायरेक्टर जनरल हायर एजुकेशन, तो ये उनके ऊपर डिपेंड पड़ेगा, हमारे ऑफिस के ऊपर जो है ये डिपेंड करेगा कि क्या इस तरह की इंफॉर्मेशन दी जाए। और ऐसे ही आपने और भी सर एग्जांपल्स दिए कि यदि सुप्रीम कोर्ट का कोई इंफॉर्मेशन है तो उनके लिए उनकी अथॉरिटी परमिट करेगी, हाई कोर्ट है तो हाई कोर्ट के जो जस्टिस हैं वो परमिट करेंगे। तो सो मेनी इंफॉर्मेशन आर देयर सर। और RTI एक्ट के दौरान मैं अभी वर्किंग के दौरान देखता हूँ कि कॉलेज में काम जो SPIO है उनके पास सबसे ज्यादा काम है, क्योंकि थाउजेंड्स ऑफ, सर मैं ये मान के चलूंगा कि एक साल में 1000 के करीब RTI भी कई बार आ जाती है। अभी जैसे क्या चल रहा था कि एक्सटेंशन लेक्चरर्स को बेसिकली अभी क्या हुआ था कि सरकार ने नई रिक्रूटमेंट की तो उनको डिस्प्लेस कर दिया गया था। तो इसके ऊपर बहुत सारी RTI कॉलेजेस में आई थी, तो जिनके पास RTI की पूरी नॉलेज थी, एक्ट की पूरी नॉलेज थी, उन SPIOs ने अच्छे से उनको हैंडल करके उनका जवाब दिया। और वन बाय वन सर आपने जितना भी हमें आज बातें बताई हैं उसके लिए बहुत बहुत धन्यवाद सर। फ्रॉम द कोर ऑफ माई हार्ट आई वुड लाइक टू एक्सप्रेस माई ग्रेटिट्यूड एंड थैंक्स टू सर। ओवर टू यू सर।
Thank you, sir. Thank you, Dr. Mangalji, and I express my sincere gratitude to Dr. Shefali again for inviting and providing this excellent opportunity.
Thank you, sir. Thanks a lot.
Thank you, ma'am. Bye, ma'am, and bye, everyone.
Thank you, sir.
So today we come to the end of this second session as well. I hope you have enjoyed all the 3 sessions today. आज तो एक्टिविटीज भी आप लोगों ने एंजॉय करी इमोशनल इंटेलिजेंस के ऊपर, और बहुत सारे क्वेश्चन भी वो आपको देकर गए कि आप जो है वो सोचिए इन सारी चीजों के बारे में। और मुझे ऐसा लगता है बहुत अच्छे प्रश्न थे उनके भी।
बिल्कुल
जो वो पूछ रहे थे कि हम अगर ऐसी सिचुएशन में हो, जब हम किसी फिक्स में आ जाते हैं, जब हम किसी डिलेमेटिक सिचुएशन में आते हैं, या फिर जब हम किसी प्रॉब्लम में होते हैं, व्हाट इज अवर मेंटल स्टेटस एंड हाउ वी आर थिंकिंग। क्योंकि अल्टीमेटली जितनी भी समस्याएं आती हैं उसके अंदर हम इमोशनल तो जरूर हो जाते हैं, and this is what differentiates us from the other species as well, that whenever we are emotional and fixed into a certain situation, वहां पर हम रिएक्शन हमेशा इमोशनल ही देते हैं। प्रैक्टिकल हम वहां पर होकर कैसे सोचें, उस चीजों को हम कैसे डेवलप करें, और किस तरह से इस इमोशनल इंटेलिजेंस से हम अपनी एक टीम क्रिएट कर सकते हैं, हाउ वी कैन हेल्प अदर्स। ये सारी चीजें, ये हमारा सारे पहलुओं को जो है ना वो मिलाती है, एथिक्स को भी, वैल्यूज को भी, और हमारी अपनी जो समाज के प्रति एक नजरिया है, या समाज का हमारे प्रति नजरिया है, वो जो हमारी अपब्रिंगिंग है, जिसके साथ जिन बिलीफ सिस्टम्स के ऊपर हम आए हुए हैं, वो सारी चीजें हमारी ऐसी सिचुएशंस के अंदर, हमारी पर्सनालिटी के अंदर निकल कर आती है। तो ये एक ब्रेनस्टॉर्मिंग सेशन मुझे लगता है कि ऐसा रहा, or we must ponder upon that to understand what is the psychology, what the other people have the psychology at that point of time, so that we are able to better understand our students, what they are desiring and what they want. और इसी तरह से आज हमारा हिस्ट्री ऑफ एजुकेशन के ऊपर भी हमने बात करी, और आज हमने बात करी RTI के ऊपर। I hope you have enjoyed all the sessions, and tomorrow we shall meet two different resource persons. कल हम बात करेंगे जो लेटेस्ट बजट आया है इसके ऊपर, टैक्स रिफॉर्म्स के ऊपर, और एक हमारा जो कल सेशन रहेगा वो रहेगा डिफरेंट पेडागोजीज ऑफ टीचिंग के ऊपर, और उसके लिए हमारे साथ आईपी यूनिवर्सिटी से डॉक्टर अंजलि जुड़ेंगे, और आफ्टरनून सेशन में जो है डॉक्टर तुलसियान जी जुड़ेंगे, जो कि अब यूनियन बजट के ऊपर हमारे साथ डिस्कस करेंगे। तो विद दिस, थैंक यू ऑल, हैव अ गुड डे।
डॉक्टर तुलसियान, ये नंबर आपने नाम दिया, डॉक्टर तुलसियान सर आपको बता रहे होंगे।
हाँ, डॉक्टर तुलसियान जी हैं जो यूनियन बजट पे बात करेंगे हमारे साथ, और सुबह जो है डॉक्टर अंजलि हैं, और